come to order. We'll begin with introductions. I'm Matt Weiner, the conference's acting chairman, vice chairman, and executive director. 5 of our 6 other council members have joined us this morning. They are Ron Cass, Jeff Harris, Mike McGinley, Matt Morgan, and Adrian Vermeulen. Since the last plenary session, we have welcomed 14 new voting and non-voting members. Their names appear on the screen, and I thank them all for giving us their time and talent. Last year, we lost a cherished senior fellow from the federal judiciary, Judge Stephen Williams of the U.S. Court of Appeals for the D.C. Circuit. Just the other day, we lost another judge, formerly Chief Judge Robert Katzman of the U.S. Court of Appeals for the Second Circuit. Those of you who have been around for a while may recall that in remarks at the plenary session nearly a decade ago, Judge Katzman suggested that we adopt, and later, along with our member Russell Wheeler, he helps us design what we call our statutory review program. That's the program under which the chairman's office identifies and transmits to Congress judicial and administrative decisions that identify drafting problems in federal statutes dealing with administrative procedure. The statutory review program was Judge Katzman's most visible contribution to ACUS of late, but it was surely not his only one. We will miss his many contributions, but more, we will miss him as a person. Earlier this week, we issued a press release marking Judge Katzman's untimely passing. It includes moving statements from several of our members who knew him best. You can find it on our website under latest news. On the subject of departures, but on a much happier note, Emily Hammond of GW Law has left the membership to join the administration, in particular the Department of Energy, and Carol Ann Siciliano has left the membership in anticipation of her upcoming retirement from the EPA. Carol Ann has been the EPA's member of ACUS for over a decade. I cannot think of a government member who has served ACUS with more distinction, dedication, and enthusiasm than Carol Ann. Thank you, Carol Ann. I look forward to welcoming you to the ranks of senior fellows before not too long. With those introductions behind us, I'll begin as our statute requires by reporting on the affairs of the conference since the last plenary session. Our funding has been secure, thankfully, for a number of years now. We recently submitted to Congress, with the White House's approval, a budget request of $3.4 million for the next fiscal year. That's the same amount Congress appropriated for this fiscal year. I thank the administration for its support. The chairmanship remains vacant. I anticipate a nomination sometime this year. And as for Senate action, I won't prognosticate on that. As I've said before, our long-term research agenda is for the next chairman to set, in consultation, of course, with the council. My main job, as I've always seen it, has been to ensure that we have enough projects directed to the formulation of assembly recommendations, free from the encroachments of partisan politics, to keep us busy until we welcome a new chairman. We have at least enough such projects. In selecting projects for the council's consideration and approval, I've tried to identify those that, 1, draw on the comparative expertise of the membership, 2, carry forward important initiatives reflected in past recommendations, such as the disclosure of what's sometimes called internal administrative law, 3, reflect the actual needs of agencies and not just remote commentators on agencies see those needs, and 4, hold the promise of resulting in consensus-based recommendations. I've also been mindful of my role as an acting official. Later today, Reeve Bull, our research director, will briefly review our pending research projects, not only those directed to the formulation of assembly recommendations, but also those sometimes called Office of the Chairman projects that are not so directed or not immediately so directed and may conclude with a report alone. Next week, we'll email you a complete list of pending and recently completed projects, accompanied by links to their web pages where you can find additional information. Before leaving the subject in Reeve's hands, I'd like to thank our members, including not least the agency officials who participate in our project advisory group, along with our committee chairs, for evaluating and suggesting proposals for new ACUS recommendations. ACUS discharges its functions most successfully, in my view, when the membership takes an active role in identifying subjects for our agenda. Please continue doing so. I'll limit most of the remainder of my remarks to highlighting some especially notable activities, some recently completed, some ongoing, some standing, of the Chairman's Office. For the most part, I'll leave for Reeve to address ongoing research studies. No doubt one of the most important functions of the Chairman's Office, as reflected in our governing statute, is to provide a forum for agencies to share information, perspectives, in more informal ways than our recommendations and associated processes allow. The Chairman's Office continues to facilitate this interchange through regular meetings of the Council of Independent Regulatory Agencies, or CIRA, which dates back to the 1980s, and the Interagency Roundtable, which we established just last year. CIRA is comprised of ACUS members from independent regulatory agencies, the roundtable of all government members of ACUS. All ACUS members are invited to attend roundtable meetings. If you are not on our distribution list for those meetings and would like to be, please ask staff to add you. At the last plenary session, I announced the establishment of another council, the Council on Federal Agency Adjudication, co-chaired by Paul Verkeil, our former chairman, Nadine Mancini, the chair of our adjudication committee, and me, and staffed by Jeremy Grayboys, our principal deputy research director. This council provides a much-needed forum for the heads of agency adjudication offices to exchange information about procedural innovations, best management practices, and other subjects of mutual interest. It also provides a forum for ACUS to identify new areas of adjudication to study. I'm pleased to report that the council has met several times already, and the signs are promising that it will fulfill its intended function even better than anticipated. We'll soon involve in its work a consultative group of scholars, some of them ACUS members, who will share their research and expertise. Since the last plenary session, we've established another roundtable that will do in the artificial intelligence space what the adjudication roundtable does in the adjudication space, and that's the roundtable on artificial intelligence. Each federal agency with membership in ACUS and each agency with which ACUS has a liaison arrangement has recently been invited to send a member to the AI roundtable. Like the Adjudication Council, the AI Roundtable will be supported by a soon-to-be-announced consultative group of leading academic and other experts outside the government. I'm sure that over time, the roundtable will identify new subjects on AI for ACUS's agenda that will build on last year's statement. Just a few weeks ago, we added a second new interagency roundtable, this one called the Alternative Dispute Resolution Advisory Group, whose membership is constituted along the same lines as the AI Roundtable. The group will share ideas with ACUS on potential new initiatives to improve through ACUS recommended administrative and legislative reforms, the design and administration of ADR programs throughout the federal government. The ADR Advisory Group will build on ACUS's long-standing study and implementation of ADR in federal administrative processes. In his remarks, Reeve Bull will mention an associated initiative, and that is our ongoing large-scale research study of ADR practices government-wide. While I'm on the subject of roundtables, I must mention the White House Legal Aid Interagency Roundtable, often known as LAIR. The Department of Justice and the White House Domestic Policy Council launched LAIR in 2012. And by memorandum in 2015, the president elevated it to a White House initiative. ACUS was named as one of a dozen-plus member agencies of LAIR. The president charged LAIR with working with, and I quote, civil legal aid partners to advance federal programs, create and disseminate tools to provide information about civil legal aid and federal funding opportunities, and generate research to inform policy that improves access to justice, end quote. ACUS played an important role in LAIR by chairing a working group established to improve the accessibility of administrative proceedings for self-represented parties. Our efforts resulted in, among other things, a 2016 ACUS recommendation that identified agencies' practices designed to do just that. We realized then, of course, that this was just a start. And so I'm pleased to report that after some years of inactivity, the President has officially reconvened LAIR as a White House initiative and again included ACUS as one of its members. We thank the President and his staff, and we pledge our best efforts to support this critical initiative. Our efforts will be enhanced, no doubt, by the involvement of the Legal Services Corporation, with which ACUS has had a long-standing liaison arrangement. LSC's president, our liaison member Ron Flagg, and his predecessor, Jim Sandman, have already met with our adjudication council to address the challenges faced by self-represented parties when navigating procedural systems designed by, and too often for, lawyers. It's one of the Office of the Chairman's priorities to identify new conference initiatives, whether projects directed to assembly recommendations or otherwise, to make agency proceedings more accessible and fairer to self-represented parties. One small step in that direction is the initiation of a new project, which Reeve will mention this afternoon, on automated legal guidance. And as he'll also mention, we just initiated a new project on the regulation of representatives, lawyer and non-lawyer alike, in agency proceedings. One last interagency working group that deserves mention. Our working group on compiling administrative records, which I mentioned at our last session, is nearing the completion of its work. The Chairman's Office established this group at the suggestion of a 2013 ACUS recommendation to prepare a guide for agencies on the preservation, compilation, and certification of rulemaking records for judicial review. That guide is nearing completion. I'd like to thank the group's members and Jeremy Grayboys at Staff Council for their truly exemplary work. In addition to these activities, the Chairman's Office will continue to sponsor forums on subjects of administrative procedure that, while important, do not necessarily lend themselves to recommendations, not at least without pre-study engagement with stakeholders of the sort forums allow. I'm especially pleased to announce that the Chairman's Office will soon convene an all-day forum on underserved communities and the federal regulatory process. This will be a start in ACUS's efforts to bring Executive Order 13985 to the fore of its work. We'll share the particulars soon. A forum on international regulatory cooperation is also in the works for this coming fall. As in the past, the Chairman's Office has continued to put out a number of publications, reports, and website resources. They include resource materials on agency procedural changes to meet the challenges of the pandemic, and our annual congressionally required report on attorney's fees in administrative adjudications and federal court cases to which agencies are parties. All will appear on the forthcoming list of projects you'll receive next week. I'll highlight now two especially notable publications. The first is the regularly updated electronic edition of the Federal Administrative Procedure Sourcebook. Published jointly with the ABA section of Administrative Law and Regulatory Practice, the Sourcebook provides an annotated compilation of the legal authorities, the APA, FOIA, rulemaking executive orders, and so forth, governing nearly every aspect of administrative procedure. Our attorney advisor, Danielle Shilkin, recently took over from Jeremy Grayboys as the staff editor of the book. Two ACUS members representing the ABA, Professor Jeff Lubbers and Bill Funk, serve as editorial consultants. They, I must add, wrote successive editions of the book when, until a few years ago, it was housed at the ABA. I encourage our members to use the book and to come forward with suggestions to improve it at any time. The second publication is the forthcoming Sourcebook of Federal Judicial Review Statutes, written by Professor John Siegel, also a public member, which will publish in print, in electric form by this fall, and distribute to agencies, the federal judiciary, and Congress, each of which will find it to be an important resource for its work. I needn't say too much about the source book at this point. As you know, a close to final draft of a part of the source book serves as the basis for the proposed recommendation clarifying statutory access to judicial review of agency action, which we'll get to in a moment. Other parts of the source book may well suggest the possibility, as a footnote in the recommendation suggests, of possible new subjects for ACUS study and perhaps recommendations as well. One is the choice of court for review of agency action, which ACUS last addressed in the mid-1970s. That issue, by the way, has important implications for a new research study we've just undertaken on nationwide injunctions and federal regulatory programs that Reeve will mention in his remarks. The chairman's office will work closely with the Judicial Review Committee. Beginning this summer, committee members willing to identify new projects on judicial review suggested by the source book and otherwise. Suggestions from members not on the committee are most welcome. This has been, of course, a thumbnail sketch of our activities. Those of you who want additional information and to read the materials I've mentioned can find them on our website. Now would be a good time to invite you to sign up on our website to receive alerts about our activities, new projects, press releases, committee meetings, our monthly information, interchange bulletins, and so forth. You have a lot of choices as to what you receive. Visit our website and click subscribe. If you need help from our staff, please ask. Now, as is customary, a word on implementation. One of the most important responsibilities of the chairman's office is to see to it that, as far as our limited resources allow, ACUS's recommendations are implemented. We continue to take that responsibility seriously. I'll mention 3 developments of note since the last plenary session. First, the Judicial Conference's Advisory Committee on Civil Rules recently recommended approval of proposed amendments to the Federal Rules of Civil Procedure governing judicial review of Social Security decisions in federal district court. This action was undertaken as a direct result of ACUS Recommendation 2016-3, titled Special Rules for Social Security Litigation in District Courts. Next week, the Judicial Conference's Rules on Practice and Procedure will take up the Advisory Committee's proposal. I thank the Judicial Conference for its painstakingly careful work over the last few years and its generous comments about ACUS along the way. Second, agencies continue to rely on ACUS's revised model rules for implementation of the Equal Access to Justice Act, which accompanied Recommendation 2019-4 when revising their procedural rules governing the filing and disposition of EJA award petitions. And third, the Government Accountability Office, GAO, just reported that nearly all federal agencies have now updated their civil penalties to adjust for inflation as required by an amendment to the Inflation Adjustment Act. Those of you who have been around for a while may recall that those amendments were enacted as a direct result of Recommendation 2012-8, titled Inflation Adjustment Act, which was based on an excellent report by our then public member and now senior fellow, Jim Chen. You may also recall that Congress projected that the adjustments would result in an increase of $1.3 billion over 10 years. Our annual appropriation, as I noted at the outset of my remarks, is just over $3 billion. Yes, Justice Scalia, we are one of the best.
Matt, you're muted.
Let me start over with this portion of the script, if I may be redundant by a sentence or two. I'd like to invite you to come forward with suggestions, however tentative, for how ACUS can improve its processes in ways compatible with our statute and the best of our long-standing traditions. This might include, for instance, proposed changes to our bylaws. You may recall that 2 years ago, we made several such changes, one the result of members' input. I'd be happy to convene an informal meeting of members interested in discussing possible reforms. Are we ready to move on to the recommendations? Yes? We'll now turn to the recommendation on today's agenda. Before doing so, I'd like to thank our members, staff, committee chairs, and our consultants for working so hard to get these recommendations done, and done so well, especially under the trying circumstances created by the pandemic. Today's agenda includes 5 committee proposed recommendations. After introducing each, I'll turn to the consultant and committee chair for brief remarks. Then we'll consider the manager's amendments. These consist of stylistic changes, some from members, some from staff, that I expect can be adopted by unanimous consent. General debate, if any is requested, will follow. We'll then consider, in the following order, council amendments, pre-submitted member amendments, and any floor amendments. You'll find in your packet each recommendation in both clean and red line form. The clean version represents the recommendation without any amendments. The red line reflects all pre-submitted amendments. We'll also show each amendment on the screen. Are we ready to move on, or do I need to address
I don't,
the?
did we cover this, the rules of debate and voting?
Just bear with me for one moment. Before we turn to the amendments, I just want to turn very briefly to the rules for debating and voting. The privilege of debate extends to all ACUS members. That includes ACUS's approximately 100 voting members, who together constitute the assembly under our governing statute, and our non-voting members. The voting members are all members of the council, government members, and public members. The non-voting members are all senior fellows, liaison representatives, and special counsels. Only voting members may move an amendment or vote. We are fully virtual for a second time, and I hope for the last time. As with any virtual event, we may encounter some hiccups along the way. Please be patient. ACUS staff members Jennifer Alvarez and Nathan Tomaso are on hand to help with any technical problems. For information on contacting them, see the document received from us titled Plenary Session Instructions. Those instructions also explain the mechanics of debating and voting in Zoom. I will briefly review them now. For each recommendation, we'll start with the managers and the council amendments, followed by the pre-submitted amendments. Only then will we consider amendments from the floor, which I hope will be in few in number, consistent with the membership's recent amendment to our bylaws, providing that first-degree amendments should be pre-submitted. If you seek recognition, please send a short chat message to that effect in Zoom. Send the message to everyone, not just the host only or a fellow participant. Include a brief statement of the reason you seek recognition. Please don't use the chat function to make substantive points or engage in discussion with other members. Chat function comments will not appear in the record of the proceedings. You're all muted by default. To avoid audio interference, when I recognize you, please unmute yourself and begin speaking. Initial votes will be taken by yeas and nays unless we can dispose of a matter by unanimous consent, which I intend to do as much as possible. If you object to an action on which I seek unanimous consent, please send a chat message that says, I object. When I call for a vote, you'll receive a message in Zoom asking you to unmute yourself. Only voting members should click unmute. When prompted, you should say yay or nay. If the voice vote is inconclusive, I'll ask for a show of hands. This plenary session, unlike the last, will use the virtual hand-raising function in Zoom. If you don't have that function or don't know how to use it, you can indicate your vote by sending a chat message to everybody that says yay or nay. Now we'll turn to some initial procedural business. The first is approval of the minutes of the 73rd plenary session, which you'll find in your packets. Is there any objection to their approval? Without objection, they're approved. The next item is the adoption of our resolution governing the order of business, which is in your packets. Based on the published agenda, it provides for 75 minutes of debate on each recommendation. The time allotted can be extended for an additional 30 minutes by majority vote. It also provides, in accordance with our bylaws, that pre-submitted amendments will be considered before any others. Your packet contains all the pre-submitted amendments. If there is any objection to the approval of the resolution? Without objection, it's approved. We ready to go to the recommendations?
I think so. Yep.
We will now, in fact, turn to the recommendations. And the first recommendation on the agenda is clarifying statutory access to judicial review of agency action. Let's make sure that we have the committee chair, the consultant, and the staff counsel ready. Is everyone ready?
I'm ready.
I'm here.
Terrific. This recommendation comes from the Committee on Judicial Review. I'd like to thank the committee chair, Kristen Hickman, and our consultant, John Siegel, for their hard work on this recommendation. Note that John, as a public member, has recused himself from the Assembly's consideration of this recommendation. He's participating only as a consultant. We'll hear first from John on his report, the source book of federal judicial review statutes in this case, and then Kristen on the committee's work. John, the floor is yours.
Thank you, Matt. Good morning, everyone.
No, I'm sorry. John, you are first, in fact. I just confused myself. Thank you.
Okay. Thank you, Mr. Chairman. Good morning, everyone. At the last plenary, I made a presentation about the larger project of which today's recommendations are a part. That's the source book project that the chairman mentioned earlier. It's a project to identify and make a grand catalog of all statutes in the United States Code that govern judicial review of agency action. So with some terrific help from the staff, that project got done. The staff identified about 650 judicial review provisions. It made this grand spreadsheet that characterized all these provisions according to various characteristics. I read all those statutes and then wrote a report about what I had learned, and that is the source book, which, as the chairman mentioned, will be published later this year. Excuse me, Mr. Chairman, I think you might need to mute yourself.
I have no capability of doing that, so
okay.
Somebody else could do that for me.
Okay. In the course of reading through all of those statutes, I observed some points about the statutes that could be improved. And I made a list of all of those points, and that was the starting point for the recommendation that you have before you. It recommends some ways to draft a specific judicial review statute so as to avoid problems. And it suggests that Congress pass a general statute that would cure some of the problems with existing specific statutes. The overarching theme, I would say, of these recommendations is that the availability of judicial review should turn on factors that serve rational policies. We're not suggesting that judicial review should always be available of everything for anybody. There will be times when no judicial review is available. But the distinction between cases where review is available and where it is not should turn on rational policy factors. They should not just be random moments that allow the government to say, you know, gotcha, you forgot to say pretty please when you saw judicial review. You didn't print your petition using purple ink, you know, no review for you, which is sort of what happens in some situations under current law. So this recommendation recommends fixing those situations. So I won't go over every detail of the recommendation because I've been asked to keep this very short, but just to hit the high spots, Some parts of the recommendation recommend curing actual problems. So these deal with situations in which parties have actually lost their right to review, or in a couple of cases where the Justice Department has actually argued they should lose their right to review over what I would characterize as pointless technicalities. So these include, first of all, some matters about the timing of review, such as specification of the time limit. As you see in the recommendation, sometimes Congress specifies the time limit in an unusual way that gives parties 1 day fewer than you might think they would have to seek review. That creates a trap into which some cases have fallen. So we recommend not creating such traps and fixing the existing traps. Then there's a recommendation about specifying the event that starts the time for review running, particularly with regard to rulemakings. Then there's a recommendation about the name of the document used to start review. Sometimes a party gets dinged for filing a notice of appeal rather than a petition for review, or vice versa. So the recommendation recommends that that be standardized and that errors in nomenclature be disregarded. There's a recommendation that Congress not specify the content of the document. That should just be handled by the rules. So those are all recommendations that deal with things that have, technicalities that have interfered with judicial review. Then there are a couple of recommendations that deal with potential problems. These, I have to say, I didn't notice any case where anyone has actually lost the right to review over these issues. And frankly, if I wouldn't recommend that Congress take up time on these just by themselves. It wouldn't be worth it to solve a problem that hasn't tripped up anybody. But as long as we're recommending that Congress pass a statute addressing these problems, I think they are worth heading off for the future, particularly as we're in an era in which, as we know, the courts tend to be more textualist, where the statute says something, they might be more inclined to say, well, that's what the statute says, you have to do it. So the two recommendations that fall under this heading are one that says, where Congress tells you to go seek review in a particular court of an agency action, that court shall have jurisdiction to hear the resulting case. There are some statutes which say go seek review in a court of appeals, but they don't give the court of appeals jurisdiction to hear the case. So the court should have jurisdiction. And then there are numerous statutes that say when you start a case by filing, for example, a petition for review, you're supposed to serve it on the agency involved simultaneously with filing it, which made me wonder, well, what if you serve it the next day? Would you get kicked out for not serving it simultaneously? So I recommend that. And then finally, one last thing that's in a category by itself, which is fixing a problem that has arisen with a previous ACUS recommendation, the race to the courthouse problem, which ACUS solved quite successfully back in the 1980s. As is detailed in the report, a technical problem has arisen. This was not ACUS's fault, as senior fellow Alan Morrison pointed out in the committee deliberations. This is the result of the way Congress happened to write up the way ACUS recommended it. Under certain circumstances, the race to the courthouse solution that ACUS recommended gets interfered with by a technicality, and the last recommendation recommends that be. So that's a quick overview of the recommendations, and now I'm happy to yield the floor to the committee chair.
Thank you, John. Kristen, please.
Thank you, Matt. And I want to start by thanking John for his wonderful work as the consultant on this project. And I also want to thank Reeve Bull and Bobby Ochoa for their support and assistance throughout the committee's work on this recommendation. The Judicial Review Committee met last fall before Professor Siegel finalized his source book to talk about his findings and what a recommendation might look like. This spring, the Judicial Review Committee met 3 times to consider and shape this recommendation. Along the way, we had substantial participation from several members of the committee, as well as representatives from several agencies, including the Department of Justice, and we also had 1 member of the public participating. To the best of my knowledge and recollection, there was no particular issue that divided the committee. Instead, we just had a great deal of discussion and put a tremendous amount of care into thinking about the precise wording that was used. We also carved off a couple of issues as potential future projects. One topic that was discussed off and on was the idea of taking this recommendation and using it as a basis for drafting statutory language to send to Congress. A council amendment to the recommendation that we will consider today calls for the office of the chairman to do just that. Although the idea was discussed in the committee, it was never formally added to the recommendation, hence the need for the council amendment. Additionally, Senior Fellow Nina Mendelsohn, together with Senior Fellow Allison Zeev, raised a belated concern about issues that the recommendation as written might raise in the context of direct or interim final rules. Proposed language to address those issues was circulated to members of the Judicial Review Committee and posted on the ACUS website last night. And we will discuss those issues and the proposed language at the appropriate time in our deliberations here today. And with that, let me turn it back over to Matt.
Much, Kristen. Thank you, John. And thank you, Kristen, for your very hard work and that of the other committee members. A lot of thought and time went into this recommendation, to say the least. We'll start with the manager's amendment. Is there any objection to the adoption of the manager's amendment? And I'll give everyone just a few minutes to register any objections that may exist. Without objection, the manager's amendment is adopted. Let's now turn to general discussion. Are there any members who wish to be heard on the recommendation generally? General comments on the recommendation. I'll give you a few minutes. Peter Strauss. We'll hear first from Peter Strauss by way of general comments. Peter?
Yeah, thank you. There's an overall issue that the recommendation, probably appropriately, does not address, but that I encountered a number of times when I was general counsel of the Nuclear Regulatory Commission. And that's the use of the word order in statutes providing for judicial review. Under the APA, an order is the product of an adjudication, not a rule. And that has on occasion caused confusion about which court has review authority for orders as distinct from the court that might have review authority for rules. It's not an issue that's addressed here, and maybe it doesn't need to be an issue that's addressed here. But if we're talking to Congress about how appropriately to draft statutes, we might call their attention to this problem.
This issue may have been discussed briefly in the committee, but I'm almost certain it's something that you've given some thought to. Can I turn to you in the first instance, John?
Sure. I mean, my understanding, perhaps Professor Strauss will correct me, but my understanding is that at some agencies, at least, issue an order adopting a rule. And so while an order might be thought of as the result of an adjudication, I think it can also have that other meaning. Is that not right, Peter?
Oh, the APA is quite specific about what an order is. And an order is the product of an adjudication.
Well, then I guess I have to just say I don't think we gave that sounds like a reasonable suggestion, but I have to say we didn't give that much consideration in coming up with this recommendation.
Peter, that's something that we could give further thought to. I mean, there's certainly been case law on this subject of late involving, among other agencies, the NLRB, which has tried to argue that an order is a rule for purposes of judicial review, or excuse me, that a rule is an order for purposes of judicial review. But I can certainly promise that the chairman's office will look further into that issue in consultation with you to see if that might be an appropriate subject for a subsequent recommendation. Could be a quite short recommendation.
Part of the problem here, of course, is the way in which the Supreme Court is now approaching issues of statutory interpretation.
Anyone else? Does anyone else wish to be heard on Peter's point? It's certainly a good. It's important. It's an important issue, no doubt. Is that Victoria Norse?
Yes, it is.
Victoria, please.
Can everyone hear me?
Yes.
Okay. I just want to second Peter's concern. I also wanted to, because of the election and various COVID-related reasons, I wasn't in the consultations for the committee. I want to say thank you to them. This is very important work. I'm a scholar of Congress and statutory interpretation, and this is exceedingly important, and also something that can be done fairly easily. So I want to applaud Jonathan and the committee and Kristen for doing this. I do think there are other issues, as Peter, and this is why I raised my hand initially before Peter made his comment. This is the kind of thing that can have exactly what Justice Scalia said, a big bang for your buck. There are a lot of issues that the court is considering, as Professor Strauss indicated, given their new textualism, that we could assist on. And I hope that we can do this in future projects coming up. I have a couple of suggestions for next year. And maybe Peter's suggestion could be involved in that project as well. Final note, I think if there's not already procedures here to send this to the legislative councils, who are the professional drafters in the House, in particular in the House and the Senate, as well as the judiciary committees, I think that those procedures should be implemented.
I'll take the last part of your comment in a moment. Thank you. That's a very perceptive and important comment. The office of the chairman would be happy to, and I'm sure the Judicial Review Committee would be happy to participate in further discussions with respect to possible other statutory changes that might be appropriate going forward, whether with respect to the order rule question or any others that Victoria and other members may identify. Anything further from the, and again, Victoria, I will get to your last comment about legislative council. Anything further by way of general debate, discussion?
You have Don Elliott and Jack Bierman wanting to speak.
Okay, so let's hear from in the following order: Don Elliott and then Jack Bierman. Don?
Sorry, I pressed the wrong button to unmute myself. We did discuss something very close to Peter's point in the committee. I remember raising the issue that the APA applies more broadly than simply to orders and applies to, final agency actions. So we can certainly take this up in a subsequent recommendation, but I think it might be rather easily fixed here by saying after order or other reviewable agency action. So I just throw that out as a possible solution.
Let's hold Don's comment in reserve here, and we'll get to that in a moment. Jack Bierman is recognized. Jack?
I'm trying to unmute. There I go. I couldn't get myself to unmute. Thank you, Matt. My general comment on this was very similar to Peter's, in that there's very clear attention to the triggering event for counting the time for a rulemaking, and there's not much attention to other actions, orders, and informal actions like informal adjudications and that sort of thing, in terms of what the triggering event is for the timing of review. And I'm wondering if the committee discussed that, if that was something, because it seems to me that, I know that the recommendation says that Congress in this new statute should specify the triggering event for all these other things, but I'm wondering if the committee thought about, looking at the law as we have it, if there was any discussion of what the current understanding is or should be on what the triggering event is. And I just want to add something else, which is that this rule order business, it's correct that the APA calls everything either a rule or an order, and an order is the result of an adjudication, the rule is the result of a rulemaking. But for example, I believe I'm correct that the Federal Communications Commission it calls its rules orders. It says, first report an order, for example, as it's when it makes a rule. So I think it's a little bit ambiguous under current understandings. But I'm more concerned about the first part, which is, what is the triggering event, or did the committee talk about the triggering event for non-rules?
I can speak.
John?
To that. Yes. Well, I think the answer, Jack, is that first I'll tell you why I did this, and then I'll ascribe what I thought to the committee. The triggering event for rules came up specifically because I observed the specific problem that the recommendation discusses in my research for the source book. But then more generally, why didn't I go into what the triggering event should be for adjudications? I think the answer is that adjudications are just so much more varied in what they are. I mean, rulemaking has typically a much more constricted, prescribed path, which typically ends with publication in the Federal Register, although, as we'll hear in the discussion of direct final rulemaking and interim rulemaking, that needs to be addressed as well. But what is an adjudication? So many different things. Given that the APA defines adjudication as anything other than rulemaking, I think it's much more practically difficult to specify what the triggering event should be that should start the time for review of an adjudication, since adjudications are so tremendously various in what they are. So that's why I didn't address that point in my report. And I don't think it was discussed much in committee, but perhaps Kristen could speak to that as well.
Yes, if I may. I know that we talked about it a little bit. We did deliberately, in the recommendations, not use the word rulemaking, but rather we use words like an agency's action, which is deliberately a little bit broader than rulemaking. But I will also point out that John's right that the recommendation was aimed at what he was seeing with respect to specific judicial review statutes, and so sought to correct that problem. We weren't trying to rewrite the APA's provision that allows for judicial review for final agency action, for example. So it's not that we're trying to encompass all judicial review and prescribe a particular triggering event for every type of agency action. Rather, the recommendation is aimed much, much more narrowly at the specific statutes that are on the books currently based on John's research, and to try to provide some uniformity with respect to those statutes. So we're addressing a much narrower problem. That doesn't necessarily mean we shouldn't consider the order versus rule issue that Peter and others have mentioned, although I would say potentially that the reference to an agency's action at least covers some of that. But in any event, that's sort of the way I think the committee approached the problem, not as we're trying to cover the entire waterfront of judicial review, but rather that we were honing in on a very specific problem that John had identified with respect to specific review statutes.
Ron Cass is recognized, and then Jeff Lubbers.
I would just suggest that while this is an interesting issue and one that's worth looking at, that maybe we should look separately after this project at whether we want to take up something on triggering events and the way it should be framed as a default matter for the statutes, the same way that Jonathan's work does for the set of issues addressed here. But I think it's too complicated to try to draft something to add to this particular report and recommendation today. So I would thank people for raising it and put it on the agenda to come back to in another proceeding.
Jeff Lubbers.
Yes, that would be fine with me. But when Peter made his point, I thought I remembered that years ago when the Hobbs Act was passed, the Administrative Orders Review Act, it referred to orders, of course. And then the question was, well, what about the review of rules by those agencies? And the courts engaged in kind of a fiction that, well, we'll interpret orders to include those agency rules. And so I'm not sure the Hobbs Act has ever been fixed or, amended to reflect that. But that, I think, might have been what Peter was referring to.
Well, that's the issue, Jeff, that came up in the NLRB cases that I mentioned. I'm not sure that the courts haven't done a pretty good job sorting this out, but it's certainly something that we could take a further look at with an eye towards a successor project. Any other general debate on the recommendation? All right, let me turn to the we have few pre-submitted few pre-submitted amendments on this recommendation. There is one amendment from the council which I will take up first, and this is apropos of Victoria Norse's point. If you will look at, and it's something that Kristen mentioned as well. If you look at page 9 of the recommendation, it's now up on the screen. The council is proposing the addition of an additional sentence that says, the conference's office of the chairman should prepare and submit to Congress a proposed general judicial review statute for consideration that would provide for the statutory changes in paragraph 4. The idea here is that the chairman's office, in consultation with Kristen and John and perhaps several other members of the Judicial Review Committee, would prepare bill text. And the bill text, we would use the bill text when we take the recommendation up to the Hill, and share it with the relevant committees, as well as Victoria mentioned the offices of legislative counsel. Is there any, Kristen, my understanding is that it's probably the sense of the committee that this particular recommendation should be adopted. Is that right?
Yes, Matt, my recollection from our meetings is that we talked about it as if it was sort of assumed that it would happen. We just never formally took a vote to include language to that effect, or we never specifically included language to that effect in the recommendation prior to this council amendment.
Okay, thank you, Kristen. There's also a corresponding amendment to the preamble, which would simply contemplate the Office of the Chairman's drafting and submission to Congress of a particular bill text in accord with the terms of the recommendation. Is there any objection to the council amendment? Without objection, then the council amendment is adopted. We have one pre-submitted amendment, and that's from Alan Morrison. Alan, are you there?
I am here.
It's a small one, but let's recognize you here and see what the committee thinks of your proposal. So Alan would move from it on page 1, beginning at line 3, he would move the text in the footnote into the text that's above the line, thereby adding a sentence that says, judicial review is also governed by judicially developed doctrines. It's really a matter of whether that statement is placed in the text or in a footnote. Kristen, may I turn to you on that? Or Alan, do you wish to be heard on that, or is your sort of change self-evident?
Thank you, Matt. I think my change is self-evident. I had kind of hoped that this would have come in through the manager's amendment, since it is totally non-substantive. And there were a couple of misaligned footnotes there that I also corrected at the same time. But I don't think it requires a debate of the assembly. But
all right. The reason it wasn't put in as a manager's amendment is that first sentence was worked over so much by the committee that we didn't want to be presumptuous and assume that it was simply a stylistic change. Kristen, do you have a thought on this, the Morrison amendment?
I have no objection to it myself.
Does anybody have any do any voting members have objection to this change? Alan can't move an amendment. I'll treat it as my amendment, and we'll deem the amendment adopted by unanimous consent. I'm going to turn to going to turn to Jack Bierman next, who submitted some written comments to us after the time this red line was prepared. And so I'll just turn it over to Jack to go through the issues that we have as quickly as possible, Jack, because we do need to get to at least 2 other issues, including Nina Mendelson's comment. Jack,
Yes. Thank
you're
you.
recognized.
Thank you, Matt. Yeah, the one about line 50, I withdraw. In further reading and reading the report, it wasn't important. The one about, I think the one, and I used the line numbers from the clean version, so I apologize to the assembly. So the second one, I'm sorry.
We need to just need to make sure that everybody knows what you're referring to, because your comments are not reflected on the red line. So just identify the relevant part so everybody knows what page you're on.
So I'm not going to mention the one that was originally about line 50 since no one has it anyway. On lines 160, at line 160, let me think. No, recommendation 4E, 156 of the 150, where you're at 156 now. Yeah, I feel queasy about this, and I'm not. It's more of a question of, do we want to include this or not, or maybe amend it, because it seems to me that Congress may have had a reason for some of the particular content that it requires in petitions. And I was thinking by analogy of notice of claim statutes, which often require that agencies be given very specific notice of what the person is asking for before they can go to court to challenge something. So I just wanted to, I guess it's not specifically an amendment. I would strike it or amend it to say that instead of saying that the applicable rules of court, I would say something like that the court is required to allow the party seeking review to cure any defect due to content, as long as the petition or complaint was filed at the appropriate time and gives sufficient notice of what is being reviewed. That was my idea, and maybe I'm just wrong about this, but it would seem to me that there must be situations where Congress had a reason for including the content, requiring the content, and this starts bordering on substantive amendments of existing statutes.
Kristen and John, does this make you feel similarly queasy?
Can I speak to it?
Please.
Yes, please.
Well, let me give you a little of the background. In my initial draft, the recommendation that was on this topic said Congress should not specify the required content of the petition for review or other document initiating review. In my review of 650 judicial review statutes, what I discovered is that there are 2 main statutes in which Congress specified the required content of the petition for review. One is the Hobbs Act, and the other is the statute that generally provides for review of orders of the FCC. When Federal Rule of Appellate Procedure 15 was drafted, it said the petition for review should be kind of like a notice of appeal. It should just say what order is under review and what court you're seeking review in, and that's it. You should not be required, for example, to say what you think is wrong with the order or what relief you're seeking, which is what the Hobbs Act required. In accordance with the Rules Enabling Act, that rule, Federal Rule of Appellate Procedure 15, superseded the Hobbs Act, and the DC Circuit has specifically ruled that you no longer need to comply with the Hobbs Act requirement of specifying what you think is wrong with the order under review. And the rules makers, who Jack, I presume, gave deep thought to your point, said, experience shows that it's just not worth trying to get the party seeking review to say anything other than here's the order I'm seeking review of, and here's the court in which I'm seeking review, and everything else will be specified later. And so that has been specifically held to override the Hobbs Act. It hasn't specifically been held to override the FCC judicial review provision. Logically, it should, but I think FCC practitioners, being cautious lawyers, still tend to comply with the FCC Act's requirement that they say what they don't like about the order under review. Anyway, so looking at all of that history, I just said, let's recommend that Congress not specify the content of the document initiating review. Back in recommendation, paragraph 3, this got watered down a little to saying Congress should be aware that it need not specify the required content. But then, as you point out in recommendation 4E, something stronger than my initial draft got put in. So it got partly weakened and partly strengthened. So I agree there is kind of a funny dual quality to what we have. If I had my druthers, I would go with the stronger version. And let me just say one more thing about your point that, maybe Congress had a specific reason. Maybe it did. But one thing that comes through from my research into all these, hundreds of statutes is I think at least most of the time the people drafting these statutes, they have no idea. I don't mean to be disrespectful or anything, but I think what happens is they just copy whatever was in the last statute that they passed on judicial review. They just copy it into the next statute without considering whether it's equally appropriate or not, and they put in all these provisions that are completely redundant, and they put in strange variations on the standard of review that courts just ignore. So it is certainly possible that Congress could have very good reasons for doing this, but I would say in this particular area it is equally possible, if not more possible, that Congress drafts the specific judicial review statute with not a great deal of thought.
Well, if the committee and the chairman both feel that this is an appropriate recommendation, then I'll withdraw that. The only other thing, very quickly, at the very end, the recommendation you have. Go ahead.
Is this on the same point?
No, I had one other thing.
Well, Peter Strauss, I believe, wanted to be recognized on this point.
Okay.
Matt,
And
if I may be heard.
Kristen first, then Peter Strauss.
So just with respect to the incongruity that John mentioned between recommendation 3 and recommendation 4E, I think the distinction between the two is that with recommendation 3, we didn't feel comfortable telling Congress it couldn't, require content or specify the required content if it wanted to. So we watered that language down. But then to the extent that recommendation 4 is more aimed at what we think Congress should adopt as the statute, I think we went along with John's recommendation there in terms of the stronger language for, our vision of what the statute would look like. And that explains the seeming incongruity between recommendation 3 and recommendation 4E.
Peter, did you wish to be heard on this point?
Yes, I did.
Please.
Subsequent to the committee's work, the Supreme Court decided the case of Ms. Chavez, attributing, thanks to Justice Gorsuch and his tendency to wish to turn very square corners, and textual, well, sometimes not so square, but surprising, but nonetheless, square corners in the reading of statutes, that the article in a statute required the government to do everything in a single document and not in 2 stages as was done. And that opinion makes one queasy about this kind of recommendation that says, well, whatever, you can do it in pieces. The Supreme Court has said in a different context, to be sure, you can't do it in pieces. And yes, there's a rule by which the courts have gotten rid of the Hobbs Act, they hope. But again, square corners, I kind of doubt that the Supreme Court is going to say that rules can overrule statutes.
Any response, Kristen or John? Victoria, did you have a comment?
Yes, sorry for using the old-fashioned and new-fashioned hand. I agree with Peter. There is a concern here. However, Ms. Chavez involves a notice to appear in the immigration context. And so when I read this, I thought, well, these are notices of appeal, as John has said before. He's looking at a specific set of statutes. On the other hand, having said that, I wonder, this is just an informative question. As I told you, I apologize because of the election and COVID. I was not at the meetings, but what do the committee members think about Ms. Chavez and its application I had assumed it was not applicable because it's a notice to appear in an immigration proceeding. But I wonder what John and Kristen have to say about that.
Well, I think the answer is that whatever might be the case about the ability of a rule such as a federal rule of appellate procedure to override statutes, here, what is being recommended is that Congress pass a statute that would provide that people seeking review can comply either with the specific statute or with a rule of court. So I would have to think that that would address the concern that's been raised. Because if Congress passes a statute saying it is generally sufficient that you comply either with the specific review statute or with the applicable rule of court, then there is statutory authority for it.
Bill
That was
Funk,
my thought as well.
Bill Funk, you wish to be heard on this point?
So I just put on the comment that I withdrew because John made my point that this is a statute we're recommending.
Kristen, did I cut you off? Did you have something further to say on this issue?
I was simply going to second what John said as well. I will point out that I think even Justice Gorsuch would go along with a congressional statute.
Anything further on this point? Jack, let's move on to your next comment, please.
Okay, great. And this is in G. If any court was ever insane enough to throw out a petition because it wasn't done exactly simultaneously, I suppose they might also be insane enough to say, well, you did it beforehand, and that doesn't count. It has to be within a reasonable time after. So I would amend this to add the words at the end of G, either before or after filing. So it's clear that the service can be before or after filing on the court. So in case there's a timing, if this timing issue really came up, it seems it would be worth the extra few words to make that clear also.
Kristen or John, do either of you wish to be heard on Jack's amendment?
I like it.
I have no objection. I will point out, and this is related but somewhat separate, what I do not recall is why we left 7/14 in brackets like that.
I have to say, I don't remember the answer to that question either.
Other than the fact that I'm not sure we knew which one to pick.
Mr. Chairman, may I be heard on that?
Who wishes to be heard?
Alan Morrison, on the 7 versus 14.
Please.
My recollection is that we wanted to give them a general range. We didn't want to give them a specific number as though it was inviolate. And so I think that was just a suggestion as to what we thought would be an appropriate range, and nothing more was meant by that. Thank you.
So instead of the brackets, could we make it 7 or 14? So it would read such as 7 or 14?
I'd like to be heard.
Just, I've got you in the queue, Nina. Nina, do you wish to be heard on this point?
Yeah, I think it's useful to include the reference to days like this because it implies that, 1 day wouldn't be enough and maybe 30 days is too many. So it's a nice signal of order of magnitude. You could do it simply by saying, at least 7 days before or after filing.
Kristen or John on that?
I don't have any particular objection, although such as at least 7 days is really clunky. So, I think my inclination would be just to leave it with the example of such as 7 or 14 and, as examples.
I mean, I'll just add my feeling about 7 is as I said in my opening remarks, recall that I don't think anyone has ever actually been kicked out for this. And if you only give them 7 days, I'm just concerned that, that this statute, if it got passed, could have the effect of causing someone to lose the right to judicial review they would otherwise have, which is certainly the opposite of what I think of as the point of the whole project. So that's why I prefer 14.
Is there an amendment from Ron Cass wishes to be heard. Ron?
Yes, I'd second Kristen's view of how to draft this. I would take out the brackets and say such as 7 or 14 days, and then include either before or after from Jack.
Nina?
Nothing further to add. Thanks. This seems fine to me.
Matt, can I make a quick comment?
Yeah, please, though, if everyone could just seek recognition through the chat feature, it would be much easier on my end. But please, Allison, yes.
Okay, sorry, I was doing the hand thing. It's just, I'm not sure this is substantive or not, but it strikes me as weird to suggest someone might serve a document 14 days before they filed the document. And so I wonder if we might say instead say such as within 7 or 14 days of filing. I guess it means the same thing, but I've certainly never been served with a document a week or two before it was filed. Anyway, to me, I don't know if it's a substantive change or not. I think people would probably read within 7 days of filing to mean after, but it could probably encompass before as well, for what it's worth.
Any reactions to Allison's comment? Jack, let me turn to you for a second. I know your amendment was to add the phrase either before or after filing. Are you content with the other revisions to line 167? In which case, we'll treat that as a Bierman amendment. We'll treat both as a
you're
single
talking about,
Bierman.
yeah,
So
7 or 14 days. That's fine. That's, yeah.
So it would say such as 7 or 14 days either before or after filing. That's the Bierman
Right.
amendment. We're combining the
That's
two. Jim Chen, do you have a comment here?
I just was content to put it in the margin. That's all.
Okay. Any further discussion on what we're calling the Bierman amendment, which is the entirety of the revision to line 167? Any objection to the Bierman amendment? All right, the Bierman amendment is adopted, and now we will move on to. I will now recognize Nina Mendelson and also Allison Zeev to discuss the issue that Kristen had raised in her introductory remarks. Let me turn to Nina Mendelson first. Nina?
Yeah, hi. First, I just want to apologize for raising this issue so late. I was unable to, for other reasons, to review this material till yesterday. And the issue has to do with the recommendation in 2 and 4A that the event that starts the time for seeking judicial review should be publication in the case of rulemaking. And the concern I had was that doesn't mesh well. It meshes very well when the agency is using, what we think of as traditional notice and comment rulemaking, notice of proposed rule, followed by public comment, followed by the publication of a final rule, followed by the effective date. But there's now lots of use of so-called expedited rulemaking. We called it that in the 1995 ACUS recommendation, direct final rulemaking and expedited final rulemaking. And in those cases, I'm sorry, an interim final rulemaking. And in those cases, the comment period takes place after publication. So direct final rulemaking, the agency says, unless we get an adverse comment within a specified time after publication, the rule will become effective as a final rule on a particular date. And we also reserve our right to withdraw that rule prior to the effective date. So that's the direct final rule scenario. The interim final rule scenario is they publish a rule that's immediately final, the effective date is immediate, but then they make some sort of promise to consider comments received post-publication. There are quite a lot of these. There's a Brookings study from 2017 that counts over 100, sometimes 300 direct final rules per year. GAO did a study back in 2012 suggesting that agencies did not collect comments prior to publication for about 35% of major rules and 45% of non-major rules. And based on they did an analysis of a sample suggesting that something like over 60% of those rules, the agency then did later collect comments. So the difficulty with this recommendation is that it puts commenters and potential challengers in a bit of a bind because the statute of limitations begins to run simultaneously with the comment period. So there's the terrific spreadsheet put together for this recommendation has over 30 statutes where the statute of limitations is 180 days or less. And of course, comment periods can also be of this order of magnitude. So the difficulty for a commenter who might wish to challenge a rule is they might not know if the agency might withdraw the comment, withdraw the rule altogether in response to the comment before they have to file a protective lawsuit to avoid getting tagged under the statute of limitations. At the same time, if they file a protective lawsuit, they may face a challenge in the court of, that they have failed to exhaust the remedies before the agency. And, exhaustion doctrine in rulemaking was not well developed in 1995, but it is now. And so I raised this issue with the committee. I'm content with the initial amendment that Kristen has suggested, although I have some kind of wordsmithing I'd like to suggest to it. But the basic approach, which is that the statute of limitations should be understood to be extended so that it wouldn't run until some period after the effective date rather than after publication. But I have to say, Ron Cass observed in connection with the issue raised by Peter earlier that it's a very complicated issue, and I worry that this is also a very complicated issue, and we may or may not be equipped to fully resolve it today. In any event, that's the issue that I raised, that for this category of expedited rulemaking, we need a different approach for the event that triggers the statute of limitations.
Allison, do you wish to add anything to what Nina said, or has she captured your views on the subject?
Nina captured the description of the problem. I don't see on the screen Kristen's suggestion, but can I address that?
Let's just hold on 1 second. Peter Strauss, do you wish to be heard on this problem before we get to potential
yes, I
language?
Do.
Please.
Although you may think that this is also about potential language, I thoroughly agree with Nina. And I want to add that by using the word rule rather than regulation, there is an additional kind of problem that comes up because of guidance documents, which are, in APA definitional terms, rules. I'm sorry to be such a stickler for text issues, but that's where the court is going these days, and I think we need to be aware of that.
Why is that a problem for this?
Well, because guidance documents don't need to be published in the Federal Register. Those rules don't need to be published in the Federal Register, but they are promulgated, they are repealed, and on occasion, parties have wished to get review of them.
If I may, Matt?
Yes, is that Kristen, please?
Yes. So my recollection from our discussion in the committee was that we spent a lot of time talking about whether to use the word rule or whether to use the word regulation. And ultimately, there was some recognition that not everything that gets published in the Federal Register gets labeled as a regulation. And so we opted to use the APA term deliberately. Again, I will point out that the recommendation is not specifically aimed at addressing everything that might seek for which somebody might seek judicial review, but rather is addressing specific review statutes. And so I think that in that regard, having Congress provide the event date, where it specifies an event that start in a statute as starting the time for seeking review. I think we decided that rule rather than regulation was the proper word that should be used in order to put the specific review statute together with the Administrative Procedure Act. If there's no specific review statute, then the APA would just apply with respect to any action is reviewable once it's final, unless there's a specific review statute.
But
That's
if
what
there's a
617
specific review
says.
statute that provides for specific review of rules, that specific review statute extends to guidance documents as well, because under the APA, they are rules.
Precisely.
And so they don't have to be published in the Federal Register. So the event date doesn't work.
Well, if Congress is specified, maybe John can help me remember why we went this direction beyond what I've said in this regard, but
Shall I, Matt?
Please, John.
Well, Peter raises another good point. What happened here is this recommendation grew out of a couple of cases I discovered, which dealt with, very standard rules that were issued and published in the Federal Register. And the agency said, well, the date that started the time running for judicial review was the date we issued the rule, which was a secret event that took place at the agency a couple of weeks before it got published in the Federal Register. And anyone who only sought review basing their date on the time of publication in the Federal Register was out of time. So that's what we were trying to avoid. Now, this shows how difficult it is to fix a problem without creating some other problem. I think perhaps the solution to what Peter Strauss was raising would be to make clear that that part of the recommendation applies to rules that do have to be published in the Federal Register. So I think we could solve that part by limiting it to rules that are published in the Federal Register and say that when that's happening, the triggering date should be the date of publication in the Federal Register.
Works for me.
Okay, but then the point that Nina raised, which is another very important point, and I'm very grateful to her for noticing this, because I didn't think of how this would have, I'll say I didn't think about it. I don't know about the whole committee, but I certainly wasn't thinking of direct final rulemaking or interim rulemaking, which she correctly pointed out also needs to be addressed. I think they've both raised good points.
Matt,
Yes, Allison.
So I think part of the solution that we had discussed yesterday with respect to Nina's issue would address Peter's issue. I thought we had discussed specifying that this second sentence in number 2 would say something like, where the event is the promulgation, amendment, or repeal of a rule through traditional notice and comment rulemaking, or something like that. I can't remember if we talked about.
Can we get the language on the screen that Kristen was referring to earlier? Because not every member has seen it. It's been posted to the website, but not every member has seen it for obvious reasons.
And I'm not altogether sure that this language will resolve Peter's problem, but I have an idea for resolving Peter's problem.
Well, Matt, can I just finish what I was saying?
Yeah, let's get the language. Let's get the language up. Kristen, just take a look at the language on the screen. Is this the language that you had proposed? I haven't seen it yet, so I just need to turn to you.
Yes, looks like it. And again, I have an additional proposal to try to fix the problem Peter has raised.
Well, can you put that on can we get that up on the screen as well?
I would be delighted to, and it's just a starting point. After the sentence that isn't the amendment, so where it says the event date is the date of the publication of the rule in the Federal Register, change that period to a comma and say something to the effect of where the rule is published, is so published. It's just an idea.
Ron Levin, then Alan Morrison.
Yes, thank you, Matt. I think that Nina's memo was really helpful, or maybe I should say Nina and Allison's. I was the ACUS consultant for direct final rules, so I learned quite a bit about that subject at the time. That was in 1995. But as a member of the present Judicial Review Committee, I didn't spot this issue. So I'm very glad that they have brought this out. I also think, well, just to make one hair split, Nina refers to all of these.
Let's start hair splitting on the language. Do you have proposed changes to the language?
No, I'll just let it go. What I wanted to say as a general comment was that usually Congress isn't legislating with regard to direct final rules and interim final rules at all when it adopts a judicial review statute. Rather, that happens through the application of Section 553 of the APA. And so Congress is not normally thinking about the issue in the first place, which would have a bearing on whether we can meaningfully address how they should deal with the issue if they aren't dealing with that type of judicial review at all, especially with direct final rules, where usually you don't expect there will be any judicial review. Now, obviously, we have to provide for it in the event it occurs, and Nina has pointed to at least one case where it is occurring. So it has to be possible, but it's very unlikely that Congress would be thinking, how are we going to provide for judicial review of it? Occasionally, Congress provides expressly for interim final rulemaking. I doubt they ever provide expressly as for direct final rulemaking. And so if you say, well, Congress, be sure and provide for it in your judicial review statute, that's in a context where they probably aren't authorizing direct final rulemaking in the accompanying substantive statute in the first place. So that seems a little odd. I would be entirely in favor of adding the relevant language to the general review statute in recommendation 4, because that would basically say, where Congress hasn't otherwise specified, here's a default provision. That seems fine. But whether it makes sense in the context of an individual statute of limitations statute, I'm not so sure. I don't suppose it does any harm, but I think it's a little bit of an anomaly here that you might want to keep in mind. I don't have a specific wording change to address it. I just wonder, put that on the table for someone to ponder, and maybe we should or should not try to make an adjustment.
Kristen, let me turn to you for a second with a question. We are quickly running out of time on this recommendation. This is an important issue. I don't think, my sense is that this is not one that's easily addressed, that will be easily addressed to everyone's satisfaction and with adequate certainty and assurances that it will be done correctly. Is it your recommendation that we should remand this recommendation or at least recommend paragraph 2 of this recommendation to the Judicial Review Committee for further proceedings this summer?
You know, that was one of my initial
Greg,
instincts.
I
was
can't
that,
talk right now. I'm on a conference.
Sid, you need to mute.
We're heading out. To
Can you mute him,
Kansas
please?
tomorrow,
Can you mute-
I can.
for
If somebody could mute Sid
actually,
Shapiro, that would be helpful. Thank you. You know, my initial instinct actually was to remand, and then my second initial instinct was to try to carve it out to be a separate project, so that we could move forward with this general recommendation and to just include some preamble language indicating that this recommendation was not intended to address the situation of direct or interim final rulemaking. I am still open to those possibilities. So I don't know that I have a particular recommendation so much as I recognize those are possibilities, and I have no objection to referring it back to the committee to deal with this issue.
Did I hear you correctly to say you don't have an objection?
Correct. I do not have an objection to referring it back to the committee to deal with this summer. Again, the alternative in my mind would be to put something in the preamble indicating that this recommendation is not intended to deal with direct or interim final rulemaking, and to avoid amending the recommendations altogether and put that issue off to a separate project.
Do we see any issues? Are there any, let me just ask the membership generally, are there any outstanding issues with this recommendation? And I know that Sally Katzen wants to be heard on another point. Are there any outstanding issues with this recommendation other than paragraph 2? There's too many people that seek to recognition now. I can't. We will cut way too far into the next recommendation. I mean, I'm willing to extend this for 5 minutes or so, but we're going to run out of time on the next recommendation, which is going to be, I think, fairly heavily debated.
Matt, I will simply point out that in addition to amending, with respect to the direct and interim final rulemaking issue, the amendment to recommendation 2 was not the only one. We were also going to have to amend recommendation 4B correspondingly, and then we had come up with a draft sentence or two for the preamble to reflect the change. So there are 3 separate changes associated with direct and interim final rulemaking that may need to be wordsmithed if we want to take up that issue at this time.
Without objection, the time period for debating this recommendation is extended by 5 minutes. What could be done here, and I'm going to turn to Ron Cass in a second here, what could be done here is we could remand it to the committee for a single meeting over the summer. We could potentially expand the membership of the Judicial Review Committee to include other participating members. I need to consult with Sean McGibbon, our general counsel, on the propriety of doing that. And then what we could do is we could put the recommendation up. We could hold a special asynchronous plenary session and take an up or down vote on the recommendation as amended by the committee. I really don't want to kick this off till next December. It's too long. Ron, can I turn to you?
Yes, I was going to second that approach. I think that we have some complications here we ought to resolve before voting on this particular recommendation. They're important. They're also too difficult to address by drafting from the floor, because every time we think we fixed one thing, something else pops up. And I think we ought to take the time to make sure we fix the problems we're dealing with. So I would recommend remanding this and having a separate vote later on, not forcing a vote today.
Is there any objection to remanding this recommendation to the Judicial Review Committee for further proceedings with respect to the issues that we've discussed this morning? All right, without objection, the recommendation is remanded. I know there are others who wish to be heard on these points, but I think that that disposition moots any other comments that other members may have. I'm going to turn finally, before we turn to the next recommendation, I'm going to just turn to Sally Katzen to see if she had a thought on this recommendation unrelated to the points that we've just been addressing. Sally?
Can you hear me all right?
Yes,
what I was worried about was the last paragraph, which adds that the council is going to come up with a general judicial review. I think that the time now, when it goes back to committee, can be used maybe to rework that and think about what it is that we really want to say rather than leaving it in the chairman's office. But I would like to get rid of the word general, because that evokes to me the whole regulatory review, reinventing regulation aura. This should be a technical amendments and be styled as technical amendments rather than a general judicial review statute, because that's just going to raise all sorts of political issues.
And I think that is in fact the intention here, and the intention with respect to this amendment was simply to ask the office of the chairman to put this the language that precedes it in bill text form, rather than asking the committee to do that. But the committee can take this question up on remand. And with that, we'll move on to the next recommendation. Do we have our consultants and committee chairs ready for the next recommendation? Next recommendation is mass computer generated and fraudulent comments. This comes to us from the Committee on Rulemaking. I wish to thank Kerry Colonese, who has devoted an enormous amount of work to this recommendation, and also our all-star team of consultants, Steve Balla, Reeve Bull, Bridget Dooling, Emily Hammond, Michael Hertz, Michael Livermore, and Beth Novak. We're going to hear from, and let me say at the outset, Bridget, a senior fellow, and Michael Hertz, a senior fellow, and Michael Livermore, a public member, have all recused themselves from the Assembly's consideration of this recommendation. They're participating only as consultants. We'll hear from Michael first on the consultants report, and then Carrie on the committee's deliberations. And we'll start with you, Michael.
Great. Thank you so much. So as Matt noted, I am speaking for the count 'em, seven consultants, rather than giving us each 30 seconds. But this, with seven, this was a really interesting and valuable process that actually speaks to the benefits of collaborative undertakings. I think we all learned a lot. This is the 50th anniversary, or December will be the 50th anniversary of an ACUS recommendation 71-6 called Public Participation in Administrative Hearings, which urged agencies to facilitate and expand public participation in lots of proceedings, but among them, notice and comment, had a specific recommendation that agencies, quote, invite the presentation of all views so that the agency may be apprised of any relevant consideration before formulating policy, and that, quote, agencies develop effective means of providing notice to the affected public and to groups likely to possess useful information. That was 50 years ago, and the themes are still very much with us. Since then, ACUS has had a series of recommendations, and obviously has not been the only voice so recommending, seeking fuller public participation in rulemaking, seeking to eliminate barriers to participation. And that has happened in a really extraordinary way, mainly because of development of technologies which were inconceivable back when recommendation 71-6 was written. As in so many settings, those new technologies have not been cost-free. The very characteristics which have enabled, in so many settings, amazing rapidity of communication and availability of information and participation in discussions and so on carry with them some downsides, create some vulnerabilities. And this report is focused on three ways in which existing problems, phenomena which are not new, have been exacerbated by the move online. And so these phenomena have sort of increased by orders of magnitude because of the new technologies. So that's the use of mass comments. Secondly, comments that purport to be from someone who did not actually submit them. What out in the world are almost always called fraudulent comments, what we called malattributed comments, and what the current version of the recommendation calls falsely attributed comments. And then comments written and submitted by a computer. And of course, what these three emphatically have in common is that they were, there was an avalanche of such comments during the 2017 FCC net neutrality rulemaking. And literally millions of comments that had all three characteristics. That is, say, a computer wrote and submitted duplicative comments under the names of people who had nothing to do with the comment. This received a huge amount of attention, a huge amount of upset among members of the public, among reporters, and among many politicians and other elected officials, not least because it came in the wake of the 2016 election, I think. And so we were asked to sort of examine these characteristics, this sort of commenting, and think about, how big a problem is it? And to the extent it's a problem, what should be done about it? And our research and interviews and discussions among ourselves led us to conclude, and I will say not all seven of us are in exactly the same place on every issue, but overall, that on the one hand, the huge reaction to the net neutrality carnival was overblown, that these three sets of kinds of comments, don't pose a fundamental threat to the legitimacy of notice and comment rulemaking or the validity or quality of the outcomes of notice and comment rulemaking, nor for the most part are they illegal in some way. At the same time, they do pose real challenges. They should not be ignored. And in thinking about what the actual harms are and what the appropriate responses would be, one critical thing that we did from the start, that indeed in the wisdom of the powers that be at ACUS, it was set up this way, was to separate these three sorts of comments. That mass comments don't have the same costs and benefits as malattributed comments, which don't have the same costs and benefits as computer-generated comments. And indeed, one of the justifications for having so many consultants was that we divided these up. There were two consultants for each kind of comment, and then the seventh for a sort of forward-looking conclusion to the report, which I'll mention in a second. I'm not going to go into the detail about the findings, conclusions, and suggestions of the report. We do try and articulate with more precision than is often the case, what the actual risks are. They're real, not cataclysmic, largely potential rather than actual. And the thrust of the report is that agencies ought to respond in two sorts of ways. One is by developing and publicizing policies that will encourage helpful comments and discourage or prohibit misleading or problematic ones. And secondly, that agencies should take advantage of the many and growing number of software tools that are now available to screen and sort and deduplicate and summarize and digest submissions. And then at the end of the report, there's a suggestion that, maybe a future in which our traditional understanding of notice and comment rulemaking, the proposed rule and directly responsive comments from interested persons, may not be the whole picture, and that agencies may gather public input through other mechanisms than just 553. I will stop there.
Thank you very much, Michael, and to all your colleagues on the consulting team for an outstanding report. Carrie, we'll turn to you on the course of the committee's proceedings, which were protracted, contentious, and so on and so forth.
Thank you very much, Matt. I like to think of them as being productive and insightful.
They were that too.
Which they really were. And I really just have 3 points to make by way of introduction to our discussion today. And the first point is to emphasize what Matt and Michael have already stressed, that this has been a very well-studied and well-considered draft set of recommendations that we have in front of you today for consideration. In addition to the 7 all-star consultants, we convened 4 committee meetings. We took into account and benefited enormously from the views of not only committee members and ACUS members, but views and extensive comments from members of the public as well. And I really appreciated that input, and we benefited. So the draft recommendation is carefully crafted and benefited from a robust set of considerations and input from the consultants, committee members, and the public. And I think I want to just thank everybody at the outset who has brought it together to this point. So that's the first point. The second point, and Michael alluded a bit to this, but I want to be explicit about it, that one issue that was aired with some depth and considerable insight early in the committee deliberations is whether the recommendation should either discourage or encourage mass comments, whether it should celebrate or disparage them. And the committee, I think, benefited greatly from these deliberations. And you have some comments that were shared on this final version of the recommendation by Nina Mendelsohn and Dick Pierce that encapsulate some of that discussion. But after benefiting from that discussion, the committee really, I think, clearly concluded that question about sort of pro-con on mass commenting should be outside the scope, and is outside the scope of the recommendation, outside the scope of what the consultants considered as well, and that this recommendation is really about the management of the 3 types of comments, how to docket them, how to be transparent about how the agency handles them, and so forth. So that is the intent that I think comes from the collective committee process and stands behind this draft recommendation. It is intending really not to either discourage or encourage mass commenting. It's really about this happens. When it happens, what should an agency do, or what can an agency do, and anticipating that they might receive either mass comments, computer-generated comments, or fraudulent, malattributed, or falsely attributed comments. How should they manage that? So that's the second point. And the third point is that the committee was very mindful of how different comments across these different categories can have different value in different contexts across different agencies. So I think it's fair to say that we deliberately resisted dismissing the potential value that an agency might find from any of these types of comments. And we wanted to be open to the possibility that agencies could find value from them, but nevertheless still confront the challenges of how to manage them. And I'll give just one example: computer-generated comments. One might think, well, how could this ever be of value to an agency? And one example that came before the committee in the discussions was imagine an automated system that could use natural language processing to review automatically a vast array of scientific literature, for example, and automatically distill patterns and generate some kind of report that could be useful to an agency. That might be valuable, and ought to be at least the recommendations ought at least be open to the possibility that something like that could fit into the definition of a computer generated comment and still have value to the agency. And so the recommendations are really designed to, again, not categorically make any statements about the value of the comments to the agency that fall in these categories, but rather to focus on how the agency should go about handling these comments that fall into these three categories. So thank you again to all who have participated, and I'm grateful for the suggestions from the council and looking forward to the discussion that the plenary has today.
Thank you, Kerry. And let me add that there were no dissenters from the adoption of this recommendation at the committee level after a very extensive discussion. Let's turn first to the manager's amendment. Is there any objection to the adoption of the manager's amendment? Without objection, the manager's amendment is adopted. We'll now turn to general discussion. Are there any members who wish to offer any general comments before we get to the recommendations particulars? All right, hearing no one, let me turn to the recommendation. I'm going to do this one a little bit differently because I'd like to address the title change, which has implications for other parts of the recommendation. And I would like to start with the committee's proposed change to the title, and then I will get to the council's refinement of the committee's proposed change. Kerry, do you wish to speak to the title change that's been proposed, which is reflected on the right-hand side of your screen?
Sure. I think the clearest and easiest to justify change is the addition of the word managing at the outset to make clear, again, that this is about the management of these kinds of comments. Then the third type of comment, the label used initially was fraudulent comments. The committee thought that the word fraudulent conveyed a legal conclusion about the nature of these comments that it would be best to avoid, that there would not necessarily be a determination that a comment that was improperly attributed or incorrectly attributed to someone else was indeed fraudulent. There would need to be some showing of intent and so forth. But so the committee proposed malattributed in place of the word fraudulent, and as you have before you, also the council has suggested an alternative of falsely attributed.
Let me go back for 1 second. I missed Dick Pierce, who may have had a general comment on the recommendation. Is that the case, Dick?
Yes, thanks, Matt. I just was, in a sense, wanted to follow up on Kerry's second point. I repeatedly tried to change the focus of the committee's efforts to look at the question of whether we should be trying to discourage mass comments more broadly. And as Kerry noted, that was determined to be beyond the scope of the study. And I completely support the recommendations given the limited scope of the study, but I think it's terribly important that that ACUS conducts a second study where we go beyond the boundaries of this study and look seriously at whether we should be trying to discourage mass comments. My concern is, I think, in fact, I'm quite confident in predicting that if we don't do that, we're going to see the significant spread of the patterns of behavior that took place during the net neutrality rulemaking in 2017. If you want to look at the details of that, I don't think the FCC has ever looked at them, but the New York Attorney General has, and she concluded that of the 22 million comments that were submitted in that case, the vast majority were, in her words, fake. I think if we do not do something to try to help the public understand the kinds of comments that can be helpful and the kinds of comments that are not helpful, that we're going to see a repeat of this and perhaps even an expansion where the next one will have 50 or 60 million comments, most of which are fake. So I really hope that we approve these recommendations, but then initiate a new study in which we attempt to assist the public in understanding the constructive ways in which they can participate in the rulemaking, and make sure that we let people know that it cannot be used as a plebiscite, that just counting comments is not going to be at all helpful to anyone. I did not know until I read the Attorney General's report that 7 million of the comments on one side were written by a single 19-year-old student who attributed them to 7 million other people. And I think what we will get if we don't address this more aggressively is a repeat and expansion of this phenomenon with records that are simply unmanageable and in which it's virtually impossible to identify and retrieve the comments that have actual substantive content.
Thank you, Dick. And I would refer the members to Dick's statement, which is on the plenary session website, in which he elaborates on his views. Nina Mendelson and Sally Katzen wanted to be heard on this point. I'll turn to first Nina and then Sally Katzen, and with the request that you be as brief as possible because we do need to get on to the amendments here.
Yeah, I also have a statement posted on the plenary website on this issue, and I absolutely agree with Dick that how agencies respond to mass comments is something that we should be studying, and I'm glad that there seems to be a fair degree of agreement on that. I just want to quickly make the point that that there are many of us who think that mass comments are not something we should be deterring outright. Surely everybody agrees on computer generated and fraudulent comments, but we certainly don't want to throw the baby out with the bathwater. As I've outlined in my separate comments, the APA calls out specifically that people are able to file data, views, or arguments. That's in the text of the statute. And for many, many statutes, they're unquestionably relevant. What a wheelchair user thinks about a particular ADA regulation is something that the agency should want to hear, even if that person is not represented by a trade association or an attorney. That said, clearly we should be communicating better with the public about what counts as a good comment, and we need better safeguards against, the 19-year-old with the computer and the 7 million comments. These are all serious problems, but we need to be encouraging greater participation in a process which has previously been dominated by, well-funded corporations and trade associations, where lots of people are underrepresented. We want greater participation, in a way that makes sense, not less. And agreed, it's not a plebiscite, and agencies have lots of things they need to consider, but public views are among them.
Thank you, Nina. Sally Katzen, we'll hear from you briefly.
Thank you, Matt. I would associate myself with Nina's comments and simply say that it warrants study by ACUS as a separate matter of how to somehow be constructive in inviting particularly those who have not participated in the past, the disadvantaged communities, to consider ways of bringing those people who are affected by the agency's actions to the table and to hear what they have to say. And I would just applaud an expansive view of the follow-on study. Thank you.
And you'll recall also from my opening remarks that I said that ACUS would be holding a forum on the subject this summer.
Correct.
So let's turn back to the recommendation, and in particular, let's address the title first. Carrie has already spoken to the committee's proposal. I just want to read the council's assessment of the title change and the council's modification of the title, and I'm just going to read from what's on your screen, but may be difficult to read. May be difficult to see. The council agrees with the committee that the proposed title better reflects the objectives of the recommendation, and it shares the committee's concern with the word fraudulent. The council proposes one modification to the proposed title, namely substituting falsely attributed for malattributed, both in the title and wherever else it appears in the document, for the following reasons. First, the recommendation already defines malattributed to mean falsely attributed. There is no reason to introduce another term. Second, while malattributed is used in some academic literature, including Professor Hertz's excellent article, it is not the commonly used term by agencies, Congress, and the public. It is important that ACUS titles its recommendations so that their subjects are immediately understood by the intended audience. And third, malattributed is not a dictionary word, at least. The council prefers common English words. Are there any council members who wish to be heard on the council's proposed revisions to the committee's proposed revisions to the title? May I turn to the committee through Kerry for his reaction to the council's suggested and I hope friendly amendment to the committee's change?
I certainly think that it would be consistent with the committee's deliberations to view this as a friendly amendment. There wasn't an extensive discussion really on that use of the word malattributed. I do want to echo what the council comment says about its use by Professor Hertz and his excellent scholarship. And I certainly would welcome if he has any comments on this, but I think falsely attributed is quite serviceable and meets the committee's intent, which was simply to replace fraudulent with something that was not entailing some kind of legal judgment.
Michael, may we turn to you? Thank you, Kerry.
Yeah, I'm going to resign from my position if you do this, Matt. There's really nothing more important to me. No, I look, the critical thing is getting away from fraudulent. I kind of like malattributed. I'll keep using it. But I totally get the desire to use an actual word in the English language, and I have no objection personally.
Well, the council is going to give you something else in a second.
To line 26, if with the which I would certainly support changing that malattributed throughout, but if you do that, then I would recommend on line 26 removing the word falsely there, just to avoid the tautological phrasing.
That change is made without objection, and the committee on style will review the entire document after the plenary session to ensure that there aren't any such remaining bumps. Reeve, what is the next one here? Because the council, all right. All right, here we go, Michael Hers. The council has proposed, are we on the right page? Yes, we're on line 49. The council has proposed changing stolen with appropriated. And if I recall from the committee discussion, Michael Hers had objected to the word stolen, and I'm not sure the issue was entirely debated. So why don't we turn to Michael and ask Michael what he thinks of appropriated in place of stolen?
I think appropriated is better than stolen. The problem with stolen is similar to the problem with fraudulent. It makes it sound like this is identity theft, and it's just not identity theft within the meaning of any statute that covers identity theft. Appropriated, I personally, I'd say used. I think that does the trick, but I have no problem with appropriated, which seems to me a more general and essentially applicable term, and not a legal term of art.
Is there any objection to Council Amendment 2, which would substitute appropriated for stolen? All right, without objection, Council Amendment 2 is adopted, and we will use the word appropriated instead of stolen. We now go on to the third Council Amendment, which, do you have that up? Yep, you're ahead of me, Danny, which appears at lines 78 through 83 of the preamble. This is arguably a stylistic rewrite. I want to turn to Kerry in the first instance to see if he has any concerns or comments with the third Council Amendment spanning 77 through 82.
I don't see any concerns with this. I almost would view it as a style change. Obviously, there may well be different views among committee members, and anyone from the committee who's present has a different view than that. I welcome them to speak to the issue, but I view this as largely an improvement in the style.
Is there any objection to Council Amendment number 3 as reflected on the screen? Without objection, Council Amendment number 3 is adopted. We'll turn now to Council Amendment number 4, and Danny, whenever you get there, we'll begin. So we have Council Amendment number 4 on lines 106 through 110. Ron Cass, did you wish to speak to this amendment on behalf of the council?
Yes.
Please.
Yeah. First of all, let me just say generally how supportive the council is of the recommendation and how appreciative we are of having it. I, for one, have been trying to get a computer to generate articles instead of comments, but have been unsuccessful on doing that so far. The recommendation here that's proposed by the council is really one that's designed not to make a substantive change, but to spell out what we think was intended by telling agencies that they should be transparent. I think that the list of items here is simply what transparency means to us, and we hope to the Assembly as well.
Kerry, may I look to you for any reactions or comments you have on Council Amendment number 4?
Yeah, here, and again, I welcome other comments from the committees, but I sense that there is something that is missing from what the committee intended by this particular change. And I think there's a transparency that the actions were taken that is somewhat missing here, at least on my reading of the council's change. This sounds like more of an explanation of criteria rather than an explanation or even a notice of the action that was actually taken. So I think the committee was looking for two things. One is for agencies, when they decide not to display all identical comments online, to indicate that, be transparent that they are not displaying all comments online, and then also give some notice and be transparent about a process for individuals to verify the receipt of their comments or to locate identical comments in the docket.
Anything else on council? Any other comments on Council Amendment 4? Is there any objection to Council Member 4?
Well, I would object as it is written.
Do you have an alternative?
I would propose the committee's original as the alternative.
Any further debate on the council amendment?
If I could interject.
Please,
here.
Ron.
I think the council view was that the committee's drafting was one that is not as accessible to the public, is not as clear as to what it's saying, is not as transparent. And I wouldn't mind if the sense of the committee is that they want to say that the agency should provide publicly available description and explanation of their actions and their criteria, if that captures a fuller sense of what you were looking for. And I think that probably is both accessible to the public and includes an explanation of everything that was intended originally.
Carrie?
Certainly, yeah. I think if it were to say actions and criteria, then that and as Ron also indicated with the other changes, I think that would address the concern that I was raising.
Can we get the language on the screen?
Well,
No.
And I'm not sure that's what. Yeah.
No. Go back.
Ron, do you want to repeat what you had said? Maybe.
Yeah. Go back to the way it was before so provide publicly available explanations of their actions and then pick up the rest.
Is that on the screen the way you wish it to read, Ron?
I believe so.
Carrie?
I will. That's acceptable.
That's acceptable to you?
To me.
I trust Ron and the other council members would deem that to be a friendly amendment to the council amendment. Is there any objection to council amendment number 4 as amended? Without objection, council amendment number 4 is adopted. Now we'll move on to council amendment number 5. And here again, I'm going to turn to Ron Cass. This amendment came off your pen in the first instance, but it does reflect the entire council's position. Ron?
Here, it's simply trying to capture the sense that we want the agencies, if they can, not simply to report a total count, but also to report the number of duplicative comments as opposed to the ones that are sort of separately viewed as independent freestanding comments. I think that's useful information. And insofar as agencies can do that, I think it would be helpful.
Carrie, may I look to you as a committee chair?
Sure. I think that amendment is consistent with the spirit of the committee's deliberations, which is to be transparent. And particularly, it's consistent, I think, with the tenor of the prior recommendation number 2, where if the agency has treated some comments as identical, that it's particularly given how this is worded, if resources permit, separately reporting that number would seem consistent with the overall spirit of the recommendation and with number 2 as well.
Is there any objection to council amendment number 5? Without objection, council amendment number 5 is adopted. Now we'll turn to the 6th council amendment. And once again, I'm going to turn to Ron Cass, we have it up on the screen, and now would delete the council member would delete the phrase, the entirety of line 118. Ron?
Yes, the sense here is that we're telling the agency that it may disregard a comment. I think adding the unless they find it has informational value introduces another concept that is perhaps difficult, suggests a separate particular reason for the discretion to choose to disregard it or not disregard it. And I think the language that is being deleted is in tension with the understanding, which I think Kerry captured particularly well in his introduction of the recommendation, the intention that we not be trying to inject a particular assessment of informational value, to whether there should be mass comments, to what they should be, to how computers should be used. And I think that the elimination of the phrase here is helpful in keeping with that spirit.
Let me turn back to Kerry again, and then we'll see if any other members wish to be heard on this council amendment.
I wonder, here I do think there was some discussion, considerable discussion in the committee about simply leaving it as just it may disregard the comment. Now I do realize that it's an authorizing statement. It may disregard, not that it must, but the reason that the committee had that additional part of the sentence was to remind agencies that computer generated comments may have some value. Now, I don't know if the council would consider it acceptable, and in light of Ron's explanation to the plenary here, if just the issue is introducing the word information, maybe we should keep the clause, or maybe you would find it acceptable to keep that clause to simply say, unless the agency identifies it as having value. Again, and I think that that's more consistent with the spirit of not categorically saying that agencies should disregard comments or even may disregard comments, but to remind agencies that even if they've identified something as computer generated, consider whether it has value. If it doesn't, then it may disregard it.
Let's turn to John Duffy on this point. John?
Thank you. I'm just wondering, perhaps this is a question for the committee. The statute, the Administrative Procedure Act, offers the notice and comment process for interested persons. And to the extent that the agency figures out that this is not a person, which I think still should not include computers, to the extent it's not a person, it seems to me that it really should exclude it as a comment. Now, it can use it. The agency has discretion to go out and fact find on its own. And if it finds facts that come in over the transom in any way, they can always use that information. They have to note it, I suppose, in their docket. But why should they keep it as a comment, as something that is part of the APA comment process? I don't understand. I understand. I agree. And so I support the deleting the unless the agency identifies it as having informational value, because I think that agencies always can find stuff that has informational value and use it. But I'm wondering why may isn't should. Thanks.
Kerry, and then Michael, if Michael wishes to be heard.
Early on in the scientific communities dealing with COVID, there were tens of thousands of scientific papers being written, and so many that scientists didn't have time to read them all. And there were some natural language processing tools that were being used very productively to comb through all of these papers that were being developed, identify patterns, and reach conclusions that could be of digestible form and helpful to people. And so that seems to me to be an example of a type of computer-generated comment that might have value to an agency in some context. And the committee, I think, recognized that as well, that we didn't want to foreclose the possibility that an agency still could benefit from and should pay attention to a comment that, no human wrote anything on it. Remember, it's computer generated, it's not computer submitted. So if I were to run my computer program, process through a large volume of scientific literature, then take that and submit that as a comment, it could be identified as computer generated. In fact, I might even program the computer to say, put a statement at the beginning to explain that this is computer generated, but it could have value to the agency. So that's why it's, first of all, not should, but may. And second of all, why the committee thought it was important to remind the agency that there could still be some information value or other kind of value, perhaps, from a computer-generated comment.
Back to you, Ron. Thank you, Carrie.
I think that may can be the appropriate term here, but I think the emphasis on having the agency make an assessment of informational value, while it's implicit, I think putting too much stress on that introduces some other potential problems, which are flagged in the next council comment. So I do think that leaving it with a period after comment is the right way to go.
And thank you, Ron. We'll go to John Duffy now.
So I get that a lot of this depends upon the definition of computer generated comment, and I thank Carrie for that clarification. In some respects, every comment that an agency gets, a modern agency gets, is computer generated, because I think everybody uses the computer to type up their comments these days. So in that sense, it's true. But maybe if we're trying to give agencies some idea of how they're to exercise this discretion, may disregard, we might say may disregard the comment as not being a comment by an interested person, because that at least gives them some direction to sort of include the comments you say are computer generated, where let's say a scientist says, well, I've developed this program, or I use this program, it has certain attributes, and it yields meaningful information out of this mass of data. And therefore, I will put my name on it as an interested person. But yes, a lot of the substantive comment has been generated by this program, which I am to some extent vouching for.
Carrie?
I think that is better. What John has proposed is better than eliminating, then quite frankly, the council amendment. I think the committee actually is a little bit worried about authorizing or being viewed in a way as endorsing agencies to just simply disregard comments that are computer generated. In part, we did indeed grapple a bit with the point that John made, that today, where is the line between what's human generated and computer generated when we all use computer programs to type up material? So I think that is certainly better. But again, I think the point was simply that we wanted to remind agencies that you shouldn't just adopt a categorical practice of disregarding. But I do think that it is true that you could disregard the comment perhaps as being by an interested person if you deemed it to be computer generated. In some sense, that's simply saying you may treat it as computer generated, it seems to me. So there's nothing I see as problematic per se about that, but it is still, like, I think, missing what the committee thought was important, which was to highlight that there could be some informational value still from a comment that was not submitted or generated by an interested human person, but was computer generated.
All right, Ron Cass has indicated that he supports John Duffy's modification of paragraph 4. Bridget Dooling and Mike Livermore both seek recognition. I'll turn first to Bridget and then to Mike. Bridget?
Thanks for the opportunity. So I was one of the consultants that prepared the report, and we really lingered with the possibility of computer-generated comments that may not have manifested themselves yet, but could in the future. And so my comments are motivated in that vein of trying to make sure that we don't foreclose a possibility that could really be beneficial down the road, even if we can't quite see the evidence of that in our dockets today. And so if we kept the Duffy language, I would want some sort of if clause to explain, how the agency should go about making that decision. Because if it's just a question, was a computer involved in generating this, I think that does miss an opportunity for the value of the computer generated comment to shine through. So this language ends up seeming a little too permissive to me, and seems problematic in that regard. So if we were going to keep it, I would add some sort of if clause at the end. And I'm afraid I don't know that I can do the drafting on that because I was comfortable with the initial language. But something here to explain, how the agency should go about making that decision. And perhaps Mike Livermore has language for us. We'll see what he has next.
Mike Livermore.
So I think that the problem with this language is that it's conclusory about what it means to be a computer-generated comment vis-a-vis its relationship to an interested person. Okay, so what I mean by that is that this could actually be a very kind of entangled question of whether the computer generated the comment or the programmer who programmed the computer generated the comment, or like obviously a company can be an interested person, and so it's not that one has to be a natural human person in order to be an interested person for purposes of commenting. So this just seems like an extremely kind of complex set of questions, and so my sense is that we actually did talk about this in the consultants group, and there was some conversation about this in the committee, and my sense from those conversations was that this was just too complex of a question to unpack in the context of these recommendations, especially in light of the fact that we did not cover it in the consultants report. So my sense would that it would be best to just kind of stay away from this difficult question for purposes of these recommendations.
And your preference would be for the paragraph 4 to read as how?
I would go with I'll just read it. If an agency identifies the comment as computer generated, it may disregard the comment unless the agency identifies it as having value. I think that's perfectly fine.
Ron, do you wish to be heard further on this point?
Yes. I think, again, from the council standpoint, I certainly think that saying you can pay attention to a comment if it has value, you can disregard it if it's computer generated, sort of has two separate thoughts in there. And the first thought is, are we concerned about computer generated comments? The report is saying, yes, there's a concern about computer generated comments. And the concern is that you can have a whole mass of comments that are being generated, not by someone sitting there at a computer doing it intentionally for the individual comment. And the separate thought is, how does the agency make assessments of value? My problem with some of the wordsmithing that was going on is that the agency doesn't have what the APA says is fairly modest in terms of what the agency has to do with the comments. And I think over time, we've gotten to the point where courts have layered on additional requirements of very detailed and expansive explanations of reviews of the comments that aren't in the the APA itself. I think that either going with John Duffy's proposal or putting a period after comment avoids some of the problems that we get to in directing attention to the informational value.
Jeff Lubbers, briefly, please.
Thank you. I agree with John Duffy on this. I think that this is one of the few weaknesses of the report, that it gave too short shrift to the idea of to the term interested person in the APA. I don't think Congress could have contemplated that a computer or a robot, a bot, could send in a comment. And to the report did cite some cases dealing with non-citizens and foreign governments as interested persons, but that seems clearly distinguishable. So I think this is a good solution. I think that this is a term in the APA that provides a good hook for freeing agencies from having to deal with comments that are come in from a robot or a malattributed commenter.
Kai Feldblum is recognized on this point.
So I'd like to endorse the concern that Ron Cass has raised, but speak in favor of keeping the committee language as is, because it might even address Ron's concern more. Just thinking about an agency that would be looking at this report for some guidance on how to manage a computer generated comments. I think it's helpful to say, look, despite the language of the APA, we're saying as ACUS that you may disregard the comment. Maybe because of managerial issues, or maybe because it's, not an interested person, although this is now can be complicated. However, we just want to remind the agency that computer generated comments might actually have value. We're just reminding you about that. We're going to do a whole separate analysis as to explaining to you why it might have value, but we're just reminding you. We're not actually not taking a position. So I actually think, again, coming at this totally from the outside, that there is utility to keeping the committee's initial language. And I don't think it raises the concern, again, as I agree with Ron's comment of let's make sure that all the way through, we're not yet opining on whether it has value. All we're doing here is reminding the agency, remember, it might have value.
And what is your position on John Duffy's language as not being a comment made by an interested person?
I think that's very confusing.
Okay.
I find that more problematic than just stopping after comment. That's a whole other issue.
Okay. Andrew Emery is recognized.
Yeah, I kind of actually agree with Chai's comments. Here we're specifically talking about the computer-generated comments, which I guess the only reason we'd have this language, because to some level, the agency needs to consider the relevant matter presented. So if a comment has no informational value, we shouldn't need to deal with a comment. So to some extent, I mean, I prefer either the original or just deleting for entirely, because I'm not sure what it's really offering, in a sense that if any comment lacks any informational value, then I assume it can be disregarded, unless there's some other meaning to disregarding it. I think
Ron,
I really support Chai.
Ron, do you wish to be heard further on this before we go take a vote?
I would be comfortable with deleting for, putting a period at the end of comment, or with John's language, but not with the language as proposed. So I would be certainly prepared to move to deletion of for, on the ground that if it's saying that agencies can pay attention to comments they deem having value and not the ones they don't, that is not something that differs from what the APA says on its face. So,
Michael Hertz.
My thought is a concern with the council's amendment is it's not a recommendation. It's a statement. It's a free-floating statement. It's not a suggestion of any kind. My concern about interested persons is, the committee and the consultants went around on this a lot. There's almost always an actual interested person in the background. The college student who submitted 7 million comments, those are computer-generated comments, and yet there's an interested person, the college student who programmed his computer to do this. And I think pinning it on the APA is challenging and debatable, and not something we usually do in recommendations. I say we don't articulate what the law requires. Given everything that's said, perhaps the way to phrase this is to begin by saying, if an agency develops a policy prohibiting or limiting submission of computer-generated comments, that policy should the policy should not yeah, now this is the critical point, right? But something to the effect of that the agency should bear in mind that such comments may have value rather than prohibiting them outright, something like that. I mean, I will say that just in the background here, I'm not sure an agency can, in fact, just refuse to consider a computer-generated comment if it doesn't have such a policy. And the overall thrust of the recommendation is that agencies should articulate policies about how they're handling these things rather than doing it cold.
Alan Morrison, briefly.
I agree with what Michael just said, both about interested person and also about whether this is a legal statement, which I don't think we should be making. It's a substantive interpretation of the Administrative Procedure Act as to may disregard or may take into account. So I just simply suggest that after it may take that fact into account, and then people can do whatever they want to do, which is we're not telling them to disregard it. And that I think takes into account everybody else's suggestions, and it doesn't preclude them from having policies or doing anything further about it.
Kerry?
I would favor what Alan has proposed, and then it would be fine to delete the unless the agency identifies it as having informational value clause. I also think that if it would be more consistent with the committee discussions to delete for altogether rather than eliminate the unless the agency identifies it has informational values. So if Ron is, if unless Alan's recent suggestion appeals to Ron as well, then I would say I would agree with him on just eliminating it. Andrew said it exactly right. I mean, the point here is that the agency should follow the APA, and if there's relevant information, it shouldn't disregard it.
Ron Cass, did you have anything further on this?
Yes, I think after listening to the entire conversation, I would favor dropping 4 because I think every one of the sort of modifications has its own problems here. And I think rather than trying to draft on the fly, I don't think we're adding a lot in the end with this. So I would favor deleting it.
Allison Zeeve, briefly.
Well, before Ron spoke, I was just going to speak in favor of Michael Hertz's approach, which I think is both more consistent with the APA and better policy. His approach being that, because what's on screen now is sort of a mess, but it would be up to the word value with a period. But I don't mind deleting it because if we're not discussing the possible prohibition or limitation, then I don't think we need to flag that the policy should bear in mind the comments have value. So if we keep it, I would just speak in favor of the first sentence.
Kerry, what is your position on deleting paragraph 4 altogether?
As I said, I think that would be consistent with the committee's approach.
And Ron, that would be satisfactory, at least to you and to me, and I presumably the other members of the council, unless somebody has an objection. Correct?
Yes.
Can we move as the Cass amendment, the elimination of paragraph 4? Is there any objection to the Cass amendment? Or without objection, paragraph 4 is stricken. Now we move on to what I believe is the last council amendment. Actually, it takes the form of a comment, and that's on what was paragraph 6 and is now, I believe, paragraphs, it was on 7, now it's on 6. Is that right? Okay, Ron, can I turn to you for the last time? And I think you'll be able to take a break after this one.
Well, the comment from the council really is just one that goes to making sure that the agency is not using a form of assessment of when to pay attention to computer generated and when not, that is biased by views of sort of political or other sort of senses of the agency review of these mass generated and computer generated comments. I think that the change by deleting paragraph 4 takes care of some part of that problem. And I don't know whether there's anything else that could be added here that would help prevent there being some bias induced into the way computer generated comments or other mass comments are evaluated.
Kerry?
One thing I just wanted to flag in the very end of Ron's statement just now, he said computer generated or other mass comments. A computer generated comment could be a single comment. It is not necessarily a mass comment. And that maybe that helps clarify the committee's understanding here. As to the general concern, it's a reasonable concern about whether the agencies would be biased in how they would process computer generated comments or respond to them. But I guess I would see that as a general concern about the agency's handling of any comment. I don't know that there is any language that would need to be added, or even what that language would be here specifically with respect to how the agency handles these computer generated comments. I mean, along the lines of Andrew's comment earlier, I mean, in some sense, this is all against the backdrop of a general obligation to make, good faith and, reasoned and reasonable judgments about what information is relevant. And I don't think that there's anything that's needed to be added. Even if we wanted to, I don't know what it exactly would be.
Ron, back to you.
I take Kerry's point to be it's hard to come up with language that would incorporate this thought, and the thought should be part of the understanding of what agencies should do. It is a concern that I have about trying to guard against that. I think it's a particular problem in this context if we're not using some particular tool to evaluate what comments we think should be treated differently than other comments. But the reason why we had this from the council as a question for the committee and the consultants, whether they could come up with the appropriate sort of language for the recommendation, rather than a proposal that we could not find the right wording ourselves. I'd only like to add one other thing, and that is that we went by the word stolen and eliminated that quickly. And if we could get a subvention of funds from LifeLock, I'd be willing to reintroduce the term as long as we make that trade-off. With that said, I would not propose an additional insertion into the recommendation.
Ron, where does that leave us here? Are you saying that the committee's explanation is satisfactory, such that additional revisions needn't be made to this paragraph?
It's just I can't figure out a way to draft something that I think would make the point and would do it in a way that I think would not introduce some other problem.
Okay. So let's move on. Thank you, Ron. Thank you, Ron. Thank you for Carrie. Let's move on to Council Amendment number 7. I have it brief. The council is proposing striking informal working groups on the thinking that an informal working group is not a coordinating body along the lines of OIRA, and that the line 155 already has a catch-all phrase or any other government bodies. Is there any objection to Council Amendment number 7? Without objection, Council number 7 is adopted. We have one more pre-submitted comment, and that's from Helen Serasio, and that appears on page 8, or what was page 8. Helen, I recognize you now. Helen, are you there? All right. Let's move on now. Are there any, before I ask Jack Bierman to, before I recognize Jack Bierman, I'll ask if there are, if we should anticipate any other amendments from the floor. Please speak now if you have any. Hearing none, I'll turn to Jack Bierman, who has submitted some comments that are not part of the red line. Jack, take them in whatever order you want. We are now at the end of the period, the allotted period for debating this recommendation. Without objection, we will extend the time for debate by 5 minutes. We will be cutting into Reeves' presentation by doing that, but I think it's important to get this recommendation done to everyone's satisfaction. So, Jack, the floor is yours.
Thank you. Going back to the council amendment where they just made a comment, which was now it's listed as number 6. It seems to me that given the deletion of number 4, that maybe the first sentence of number 6 should come out also. It doesn't. I mean, if an agency relies on a comment, it has to include it in the docket just by law. So I don't see why we would put that. We would have that in the recommendation.
Carrie,
the first sentence on number 6, and then I would just
go ahead. Go ahead, Jack.
Yeah. No, and then I don't know I mean, I'm fine with the first part of the second sentence. Is there? I guess I would put the word between where it says the agency should note any comments on which they rely that are computer generated. Maybe you want to say agency should note whether any comments on which they rely are computer generated. I'm not sure the purpose of that first part of that either now, in light of the deletion of number 4.
Danny, could you take out the redlining reflecting the council amendment, and then we can just focus on Jack's?
I think it would be, it's important for the second sentence, for that first sentence to be in there, because we don't want
well,
the committee.
Wait, but just stop for 1 second. What is the language on what language should be on the screen that we're now considering?
Yeah, I don't. That's up to Jack.
Number 6. I would delete the first sentence of number 6.
And I wouldn't do that. because that's integral to the second sentence.
Well, the first sentence of number 6 just restates a current legal requirement, which we don't normally.
Yeah, I mean, we if you wanted to delete that first sentence, then I think the second sentence should say, should note any comments on which they rely that the agency knows are computer generated. because we don't want to create an obligation on the part of the agency. The committee didn't want to create an obligation on the part of the agencies to find out if comments are computer generated. That's actually very hard to do if it's not disclosed. So I think if the proposal is to delete the first sentence, which I agree is not, it's not adding anything new that the agency's not already legally obligated to do, but on which they rely that the agency knows are computer generated.
Yeah, I think that's good. And
Carrie, are you satisfied with
I would be
what's on
fine
the
with
screen?
that.
All right, that's the Bierman amendment. Is there any objection to the Bierman amendment as reflected on the screen, paragraph 6? Without objection, the Bierman amendment is adopted. Jack, what do you have next?
well, as you know, I had a bunch of small stylistic things, but I think it's not worth the time to deal with them. I had one thing was the target of the recommendation about the GSA's deduplication, and now I'm confused about where it was line 92 when I looked at it last.
Recommendation number one.
Okay, so number one, I think that ought to be that the GSA should be mentioned first, so that it's clear that that's a recommendation to the GSA. So I would rewrite that to say the General Service Administration's e-rulemaking program should include a deduplication tool for agencies to use, although a GSA should allow agencies to modify the deduplication tool to fit their needs or to use another tool as appropriate.
So I view that as a stylistic change, and if it's just changing the beginning as Danny has it displayed here, and I think that would be fine.
Without objection, that change is made, and this Committee on Style will give it a further review after the plenary session. Jack, what else? Do you have anything else?
It seemed to me.
Jack, do you have anything else?
Yeah, it seemed to me that recommendation 2 was actually had two separate second recommendations, and I would break it into recommendation 2 and recommendation 3. So recommendation 2 should just be the first sentence of current recommendation 2, which is and then the first sentence, make that recommendation 2, and then new recommendation 3 would start with agencies may wish to consider alternative approaches to managing the display of comments online, and then continue with the such as in that current sentence.
Carrie?
And so yes, that's fine. Danny, put alternative in front of approaches. In 3 there, may wish to consider alternative approaches. And then everything else is the same. I don't have any concerns about that.
All right, without objection, that change is made. Jack, do you have anything else?
No, that's all. The other ones are small stylistic things and not worth the time of the assembly.
If you have small stylistic changes, you may submit them after the plenary session for consideration by the Committee on Style. I trust that there are no more amendments on proposed amendments to this recommendation, correct? All right, we'll proceed to a vote on this recommendation. All those in favor?
Matt, I had asked to speak to number 6.
Let's go back to number 6. Please, Allison, please.
Actually, I think
very briefly.
Should be number 7 now. It's now number 7.
Yeah, so I just wondered why, if an agency has chosen to rely on a comment, it needs to flag that it's computer generated. That suggests there's something maybe illegitimate about it, but if the agency's already considered and relied on it, isn't it just as, I just don't know why that's something that has to be flagged. The important point is the substance that the agency has found relevant.
Carrie?
I think it goes to this question about, and there's no, some people, as I think this discussion is clearly indicated, are wondering whether comments being computer generated, that's significant to them. It might go to whether it was an interested person issue. It's just saying, if you happen to know it was computer generated, state that. That's all it's saying. because of, I think, a general interest in this issue that is, and frankly, motivated the whole aspect of including computer-generated comments in this this recommendation.
Is there an amendment on the table here?
No,
There
I
any-
guess that Carrie answered my question, which is sort of goes to the whole thing, but that's fine.
Yeah, this one was extensively debated during the committee proceedings. I mean, I would implore that we not touch this one, but that's just my own personal view. Are there any additional amendments that anyone wishes to offer from the floor? I'll give you 15 seconds to chime in if you have any such amendments. All right, seeing none, we'll proceed to a vote on the recommendation. All those in favor of adopting the recommendation as amended, please say yay.
Yay.
Opposed, nay.
Yay.
The yeas have it, and the recommendation is adopted. Without objection, we are going to dispense with the project update that was scheduled for 2020. With my apologies to Reeve, what we will do on that front is send you next week, early next week, a list of all our projects with links at which you can learn additional information, including what the project is about, the names of the consultants, and so forth and so on. With that, we will recess for a lunch break, and we will resume at 1 o'clock, at which time we'll hear remarks from our council member, Adrian Vermeulen. For those of you having lunch, enjoy your lunch. Thank you. After our completion of the fifth recommendation, we'll turn to Reeve Bull to provide a brief overview of pending projects. Again, if we're unable to do that, we will send you a list of projects. In fact, we're going to do that anyway with links to their project pages. Let me turn to the next segment of the program. I'm pleased to recognize our council member, Adrian Vermeulen, to offer a few remarks about his new book with his Harvard colleague, Cass Sunstein, titled Law and Leviathan, Redeeming the Administrative State, published by Harvard University Press. When I read this engaging book, ACUS's work was never far from my mind, and I trust you'll see why upon hearing Professor Vermeulen's remarks. Adrian, the floor is yours.
Matt, thank you. Can you hear me?
Yes, we can.
Okay, wonderful. Matt was very kind to suggest a few words about the book. You don't have to twist the law professor's arm to get him to talk about his work before an audience, so I'm happy to do so. And I do think it's a natural fit for ACUS's work. Of related interest, there was a recent review symposium on the book in the notice and comment blog with a lot of contributions from members and friends of ACUS. So I wanted to mention that. I didn't have time to respond to that because of a deadline for my next book, but later I'll mention a couple of the most interesting responses from our own ACUS stalwarts, Ron Levin and Kristen Hickman. And I don't purport to speak for my co-author, Cass Sunstein. He's more than capable of speaking for himself. So this is my take on the book. The main claim, I think, is simple. It's an application to administrative law of a set of procedural principles of the rule of law described by the Harvard legal scholar Lon Fuller in his book, The Morality of Law. So Fuller specified 8 desirable features of the rule of law, or to put it conversely, 8 ways that the attempt to create and maintain a system of legal rules might miscarry or misfire. He said that a failure to make rules in the first place, deciding everything ad hoc, would be not law-like. A failure of transparency, if it became very grave, might be not law-like. An abuse of retroactivity, if people could never rely on the current rules under constant threat of change, might not be law-like. A failure to make rules comprehensible, issuing rules that contradict each other, rules that require people to do things they lack the power to do, or a mismatch between the rules you're announcing and the rules you're actually applying. So in the book, we apply Fuller's principles to administrative law, and we see very similar procedural themes all over the doctrine. So agencies have to follow their own binding legislative rules unless and until changed. The Arizona grocery or pardon principle. Retroactive decision-making is generally disfavored and has to be limited to prevent abuse. Official agency declarations of law and policy should match the rules that agencies actually apply, and adjudication, that like the Allentown Mac case is much like that, and so on and so on. Let me say something about first the source of these principles and then their scope and weight. So as the source, these principles are generally speaking, they're not closely tied to any particular written text. When you investigate their origin, they don't seem to be interpretation of some particular statute or constitutional provision in a number of cases. They seem to be general background principles of law that the courts invoke without worrying too much or getting too anxious about who enacts them. A number of them long predate the APA or even the Constitution. You can always say things about, well, they're inherent in due process, or Congress would have wanted them to be applied, things like this. But those are sort of post hoc rationalizations when you investigate the concrete origin of these ideas. So just to take one interesting example, the Arizona grocery principle, that agencies are bound by their own legislative rules. Why is that exactly? I can imagine it being otherwise in a sort of science fictional way. At the key moment in the 1932 decision, the court says that the Interstate Commerce Commission is bound by its own previous legislative pronouncement. The court cites literally nothing at all. There's no citation in the relevant paragraph of the opinion. It seems to just see it as an intrinsic principle of procedural justice or an intrinsic property of rulemaking. Secondly, principles like this have dimensions of scope and weight. They're hardly absolute. Fuller thought that his rule of law principles came with a floor, a kind of minimum, but they also were higher aspirational ideals for the rule of law. And above the floor, he thought that they would properly be balanced against other considerations, like the efficacy and speed of agency action. I think retroactivity is a nice example here. If you look at the Bowen versus Georgetown Hospital case, Kennedy writes to the court, and he says, without citing anything, he says retroactivity is not favored in the law. It just seems to be a principle in the background. But he doesn't say retroactivity is per se impermissible at all. So in adjudication, we balance the agency's need for retroactivity against harms to reliance interests and ask the agency for an explanation. On the rulemaking side, agencies can have authority to engage in retroactive rulemaking if Congress has clearly conferred it. So these principles like retroactivity is disfavored. They're more like presumptions that can be overcome where the need is sufficiently great. That doesn't at all make them illusory. Presumptions matter. It just means they have a dimension of weight as well as scope. Okay, those are the main claims of the book, and just a few more brief words stepping back about what is the point of these claims. Well, one thing is we think these principles really do exist and have become central to the rule of law in the administrative state. They're sort of one of the main ways our law keeps agencies within the bounds of the rule of law. So that seems important. Additionally, however, we have a more optimistic or maybe just hopeful idea, which is that this vision of the rule of law in the administrative state can help us all find some common ground. In other words, the rule of law and administrative procedure can help establish a common framework to kind of civilize our disagreement. We're not going to eliminate our disagreements, but we can find a common framework within which to have them. Now, that common ground, it won't be anyone's first choice. That's sort of the nature of what it means to compromise. So if for example, you think the real problem in administrative law is sweeping delegation to agencies, you won't be fully satisfied with these rule of law principles as kind of substitute for second best safeguards. But you know, in life, no one gets everything they want. That's sort of the nature of compromise. A brief word on the very interesting responses from Ron Levin and Kristen Hickman that I think get at this idea of common ground. So this is again in the Notice and Comment blog symposium. Ron's main point was that our strategy for finding common ground, he said, it'll be incomplete or insufficient unless it's paired with searching critiques of the doctrines like the revived non-delegation doctrine that critics of the administrative state seek to institute instead. Well, I mean, on one level, I agree entirely with Ron, as any reasonable person would. As we said in the book, Cass and I, we have our first order views on these issues, and we continue to press them. In my own case, those views are distinctly New Deal-ish. But the hard question, I think, to me is, what happens when our debates keep going, but we need a kind of modus vivendi? We need a way of getting along together in the face of our disagreements, and it seems to us that these rule of law principles are a hope for that. They have the virtue of already being woven into our law, and they seem like a highly plausible candidate for a common framework. And for that to work, you know, people can't just insist on their own first order views. Kristen raised a very interesting doctrinal question that I think illuminates a larger issue. Her question was, how would our framework apply to interim final rulemaking without a claim of good cause, where the only notice and comment occurs post-promulgation, like recent Little Sisters of the Poor case? And she's rightly troubled by this and calls that part of Little Sisters of the Poor a hyper-literalist interpretation of the APA. I mean, I agree with that emphatically, and I would say we don't need any Valerian principles to explain the issue about that, which is that textual interpretation should include more than literal surface meaning. It also includes structural inferences clearly embodied in the statute. And the structure of the rulemaking provisions of the APA seems to me to clearly contemplate a sequence in which notice and comment should presumptively precede promulgation absent good cause, and so on. And it's not harmless error, it's a kind of structural error. Well, I'm not sure that the example shows much about the fuller issue. I think it's just a case of arguably excessively literal interpretation. What that illuminates more broadly is our point is not that our rule of law principles by themselves can do all the work. It's just that the work they do is, in our view, legitimate and increasingly central to our law. But of course, other techniques for maintaining the rule of law are also important. Okay, that's all I had to say. Thank you.
Well, thank you, Adrian, so much for sharing your book. I commend it to everyone to read in their free time. Thank you again. We'll turn now to the next recommendation on the agenda, which is periodic retrospective review. And do we have our consultants and committee chair available, ready to go?
Yes. Yes.
Good. This recommendation comes to us from the Committee on Administration and Management, and for their work on the recommendation, I'd like to thank the committee chair, Aaron Nielsen, and also our excellent consultants, Lori Benier and Jonathan Weiner. Jonathan is also a public member of ACUS, and as a public member, he's recused himself from the Assembly's consideration of this recommendation. He'll be participating only as a consultant. We'll first hear from Jonathan on the report, and then Aaron on the committee's work. Jonathan?
Thank you, Matt. Thanks to the chair and to Reeve Bull and the ACUS staff, and to Aaron Nielsen for showing and supporting this project. This is a report about periodic retrospective review or periodic review of agency regulations. And as we're familiar, many agency regulations receive ex ante or prospective review before promulgation. And then there's longstanding interest in retrospective review to assess period of time how well the regulation is working. Could it be improved? The ex ante analysis accurate, or have things changed? And ACUS has repeatedly recommended retrospective review, including in a major set of recommendations in 2014. But the experience with retrospective review has uneven or episodic, limited, despite several presidential executive orders calling for retrospective review and efforts by OMB and others. And then this report goes further in looking at a one-time look back for a rule, but at repeated, iterative, periodic review. So the motivation is largely that after a regulation is adopted, the world changes, and the world keeps changing. Science, technology, society, economics may all change. So even if the regulation was well justified by an ex ante impact assessment, there may be changes, divergences over time. The benefits, costs, ancillary impacts, distributional impacts, and others may diverge or differ from what was initially forecast. And the policy options may change over time as well. So a way to make retrospective review more regular, more adaptable to change, and also successful for the agency is to make it not just a one-time look back, but an ongoing process of repeated, iterative learning or updating. And the report and the recommendations suggest that can be done in a few different ways, such as setting a schedule for the review to be done every X years, every 5 years or 10 years or something else, or setting an initial period, which time a second period is defined by the agency. And so each time the agency sets a new period for its next review, a point raised in the committee discussions by Bill Funk, or simply saying periodically or from time to time and leaving it to the agency's discretion. And ACUS has recommended periodic review in its recommendations in 1995, 95-3, also in the retrospective review recommendation from 2014-5, and in its regulatory experience recommendations in 2016-6. So in our report, we were trying to look at what's been agency experience with trying to undertake periodic review. How well has it worked? When is it most successful? And what might be best suggestions for best practice? And I want to recognize also that my colleague and co-author, Laurie Benier, is here with us as well. And so if there's time or during the discussion, Laurie may have her own comments to add as well. So one key point in our report is that periodic review is not going to be warranted or ideal in every case, in every circumstance, because there are both pros and cons of periodic review. The more things change and the more rapidly they're changing, the greater the potential gains from learning, the greater the potential gains from repeated periodic review. So that means some regulatory contexts in which things are changing a lot or quickly may be the best candidates for periodic review, but others where things are not changing very much or there's not a lot of learning to be gained may not be such good candidates. And there's, on the other hand, there are also costs of periodic review. There are costs to the agency and its staff and time, and really the opportunity costs of what it could have done with those resources. And there are also costs to society in the expectation that rules may be reviewed repeatedly may introduce uncertainty or instability that is costly to actors who would rely on the rules. Also noting that periodic review could address not only individual rules, but group rules, multiple rules, in order to try to understand interactions across rules, cumulative effects of multiple rules, and comparisons across rules and across impact assessments. And then a further factor is what's the optimal frequency? How regularly or how short or long should the period be? And that may also depend on the rate of change and the cost of those reviews. So in light of those pros and cons, our report suggests that there should be some selective process of identifying the rules most gain from periodic review. So we studied the prevalence of periodic review requirements or exhortations, and how agencies have undertaken them, what their incentives or obstacles may be, and what best practices might be. And just very briefly to summarize what we found empirically, there are calls for periodic review that are fairly prevalent in several executive orders, usually using the word periodically, not setting a specific number of years, but so in executive orders 12044, 12866, and 13563, there are calls for periodic review of regulations. There are some statutes that apply generally across the government fairly broadly and require some version of periodic review, notably the Regulatory Flexibility Act, Section 610, which starts with a review after 10 years, and the Foundations for Evidence-Based Policymaking Act, a relatively new statute, which, along with the OMB guidance, calls for evidence building plans, what OMB calls learning agendas, and evaluation plans on at least a 4-year cycle. And then we looked at specific statutes that apply to particular regulatory programs, and we found, collected in Table 1 in our report, at least 20, more than 20 statutes that call agencies to conduct reviews periodically or from time to time, but without specifying the specific number of years. And then we found another additional set of more than 20 statutes that set a specific schedule of review every 2 years, 4 years, 5 years, 8 years, 10 years. They vary from statute to statute. And we conducted interviews with OMB, OIRA, and several regulatory agencies, and we're very grateful to the agency staff who made time to speak with us. From that, we developed several findings, and I'll just mention a few, and then I'll conclude. There's a pervasive call for periodic review across executive and legislative provisions, but there is uneven implementation of those reviews. Some agencies do a lot, and some agencies do not so much. And the calls for periodic review may be most successful where they're scheduled, where the agency knows that there's a due date, even more so where there's some incentive to comply with that due date. And especially we found from our interviews where the agency designs its institutional processes and cultivates a culture through staffing and through advanced planning to really conduct these periodic reviews as an ongoing process of learning and updating rather than rushing to comply just at the last minute, but where the agency is gathering information and updating its learning continuously through a series of periodic reviews. And the last finding that I'll note here is that the question of the optimal frequency, why 5 years? Why 10 years? Why not some other number? Or should an agency reset the timing each time? seems to be very understudied. So we suggest agencies and OMB should look more closely at what the optimal frequency might be in different, which will vary from context to context. Thank you.
Thank you, Jonathan. Aaron, a few brief words on the committee proceedings.
Sure. Thank you. It was a pretty pleasant proceedings, pretty straightforward. Thanks, Lori and Jonathan, for the excellent report. The most interesting thing, my subjective view that came up was Bill Funk had a very helpful amendment, which was rather than just doing periodic, in other words, pick years, you could also have an alternate vision where the agency says at the end of one rulemaking process, this is when we're going to do the next one, and not have it always be on a set schedule. The committee found that idea helpful, and we added that to the recommendation.
Thank you very much, Aaron. We'll turn first to the manager's amendment. Is there any objection to adoption of the manager's amendment? Without objection, the manager's amendment is adopted. General discussion. Do any members have general comments on the recommendation that they'd like to share with the Assembly?
Yes.
Peter Strauss is recognized first.
So I take it, because this is about periodic retrospective review, that's a reason why as little attention is given as is given to the role of OMB in the process. But the one thing that I've found missing, I'm not quite sure that you want to change it now, but it really, to my mind, warrants changing, is any attention to the problems created by incorporation by reference, which the conference dealt with some years ago, and learned in the course of considering those recommendations that most of the regulations that had been most of the industrial standards that had been incorporated by reference were 15, 20, 25 years out of date. The standards institutes have regular schedules. They do have a periodic schedule by which they insist on revisiting incorporated standards. It would strike me as entirely appropriate, either or both, to say to agencies that they should pay attention to those proposals or to those activities of re-examining incorporated standards, or that they should be in a relationship with the institutes whose standards they have incorporated, such that they get notice whenever the standards are changed, so that they can consider their possible revision. IBR is not a part of this recommendation. I recognize that. But as a matter of periodic retrospective review, for a great number of rules that are out there, it is occurring, but it's not occurring in the administrative process, and it should be.
Thank you, Peter. I'm just looking at a comment from our engineer. Please raise your digital hand to be recognized. That is not our protocol. So can we? That is a mistake. So please ignore that comment. If you wish to be recognized, please put a statement to that effect in the chat function. Thank you, Peter. We'll turn now to Alan Morrison.
Thank you, Matt. Alan Morrison, Senior Fellow. So I have a question. I took a quick look at the report. I didn't read it in detail, but the question that occurred to me is, in theory, of course, it's a good idea to review what you've done in the past to see whether it's actually still working. And obviously, there'll be some cases in which you'll know about a problem and someone will call it to your attention and you'll change it. But has anyone done a cost-benefit analysis as to whether retrospective review actually produces the changes either in number or significance of rules that would justify imposing on agencies these requirements, which I just heard are in multiple statutes as well as executive orders? Has anyone done anything like that? Because it struck me as being that you're potentially unleashing a lot of busy work on agencies, which, as your report points out, they have a lot of other things to do besides this. Thank you.
Let's hear from Jim Tozy, and then perhaps Jonathan Weiner may have a response to Alan. Jim?
Yeah, Alan, I think you raise a Very good question there. And I think one of the first questions you have to ask yourself is, what's for an agency to do a retrospective review? Why would they want to do that, and how help them? Because the question you asked, and what you stated, is it's a very costly exercise, and analytically it's extremely difficult, because when you have an ex post evaluation, you have all these intermediate impacts and variables that affected that. So to pull that analysis out and do it separately is very difficult. Now, some agencies has done quite well. I think the Department of Transportation, when Neil Eisner was there, did quite a few of them. But if you look at the ones they've done, a lot of them are very discrete programs. But you take some of the ones that EPA does, and it cuts across a lot of programs. So I think the question you ask is a very relevant. I think in theory it makes a lot of sense. Practice, how it's done is a different issue.
Jonathan, did you want to respond to either Jim's or Alan's comments?
Sure. It's a very good question. And in our report, and I think in the recommendations, although Aaron Nielsen can speak more, do not advocate imposing new periodic review requirements on agencies. We do advocate considering the pros and cons because, as Alan said, it can be costly. And it's a good question. And we also advocate identifying the rules for which the gains or the benefits of periodic review will be favorable, where the world is changing a lot. What we found is that there are a lot of requirements for periodic review across the statutes that do not provide their own justification for how frequently they ask for that kind of review. And there is a literature that tries to look at a retrospective review of retrospective reviews. People like Michael Greenstone, Winston Harrington, Nick Morgenstern, and Art Frost, and Maureen Cropper, and others who have tried to look at, and they've, and also OMB did its own analysis of retrospective reviews in the early 2000s, and they find some degree of learning and improvement. And I think some of the people in this meeting, or who've been mentioned recently, like Carrie Colonisi and Cass Sunstein and others, have written on this topic. The other thing I'd mention is some of the examples of periodic review in our report that we find to be the most successful are really about updating rules or standards, not about a one-time retrospective review of a single passed rule. So for example, EPA's review of the National Ambient Air Quality Standards required by statute by the Clean Air Act every 5 years is one where we found the agency had really incorporated that into its processes and culture, and with a dedicated team gathering information and conducting those reviews on a nearly ongoing basis. Or the Dietary Guidelines for Americans issued by, I think, USDA and HHS, which again had an ongoing review process, and those seem to be working fairly well. So, it's a good question, and that's why our report talks about the pros and the cons.
Sally Katzen, you're recognized.
Thank you. I think there are two different drivers for retrospective review. One is the thought that if an agency did a retrospective review, it might learn something about its own processes and its own way of evaluating things, and it would benefit from that. And in ongoing rulemaking proceedings, it could incorporate the lessons learned. That's a we can learn from our mistakes and fix them kind of approach. The second, which actually goes in a very different direction is more politically based, not analytically based, and is predicated on there's just too many rules, they're all obsolete, they're all terrible, make the agencies go through them one by one and evaluate and hopefully get rid of that rule and everything else that touches on it. Well, these two drivers do go in two different directions. And I think that's the schizophrenia of this whole area. And I'm not sure where that takes me, but I thought it might be helpful to just be very clear about what we're talking about here.
Thank you, Sally. Any other general comments? We'll turn to the first council amendment, which we have up on the screen, and it obviously apropos of several comments that have already been made about agency resources. This amendment would provide that the conference recognizes that agencies will need to consider available resources in deciding whether periodic retrospective review program should be implemented, and if so, what form it should take. The recommendations offered below are subject to that qualification. Aaron, do you wish to be heard on the council amendment?
Sure. I mean, it feels like we do this every plenary for at least one of the sets of recommendations. They're always subject to resource constraints. We always acknowledge that. I think we could have an asterisk for every single one of our recommendations. So for me, I don't think this is necessary. I think it's redundant, but I don't oppose it. It's inherent in the nature of a recommendation that is subject to resource restraints. So I have no objection to it. I don't think that the committee has an objection to it. I also don't think it's necessary. I think it's redundant.
Any additional comments on the council amendment, whether from the council, any council members or others? Ron Cass is recognized.
Thank you. Some things that go without saying are better said. I think this is one of them. I once made the mistake of introducing a friend at a talk and saying, this is someone who needs no introduction, and therefore I didn't give him one. He's reminded me of that periodically since then. I think that particularly given the sort of concerns that have already been expressed about the cost and intrusiveness and the questions respecting how you go about this sort of review and what you get out of it, I think it's worth stating that we're sensitive to the resource implications of this, and the recommendations are offered in that light.
Anyone else wish to be heard on the council amendment? Is there any objection to the council amendment number one? Without objection, council amendment 1 is adopted. We'll move on now to council amendment number 2, which appears on page 7. The council amendment appears on lines 113 through 114 and would add to the phrase historically underrepresented or under-resourced groups that may be affected by the agency's regulations. Let me turn that over to, I think that amendment is largely self-explanatory. Let me turn to Aaron for his reactions in the first instance, and then if any council members wish to be heard further, we can hear from them.
I think the committee would think that's a helpful amendment. It's consistent with what we were trying to do. If a committee member disagrees, they can speak up, but I think that's what we were trying to do.
Are there any committee members who wish to be heard on this amendment? Is there any objection to this amendment? Without objection, council amendment number 2 is adopted. I'm going to turn now to floor amendments, and first to Jack Bierman, who submitted submitted at least one amendment that's not on the red line, but appears on our website. Jack, is your amendment now moot?
It's a Matt. It's a matter. This one is a matter of style, and I won't take the assembly's time with it.
Okay. Are there any other amendments from the floor now that we've finished the council amendments and now that given that there are no pre-submitted amendments? Peter Strauss, recognized.
Thank you, Matt. I recognize that you didn't take much of my original comment, and I can't myself make an amendment, but I would hope that someone would be willing to offer as an amendment language like the following. Agencies that have incorporated industrial standards in their regulations should arrange to be notified by the adopting standards organizations of relevant revisions to those standards the organizations may have made, and consider adoption of any such revisions. I'll say again, ANSI requires periodic revisions to standards every 5 years. Many standards that have been incorporated by reference are 10, 15, 20 years old. They are what remain the law. The revisions do not govern, and sometimes the original, that is the legally binding standards, are no longer easily available to people to find out what they are bound by. Perhaps this is not so large a practical problem because of want of enforcement or the like, but as long as we are addressing the periodic retrospective review and the frequency of review, it seems to me that that ACUS should recognize this interrelationship with an important source of regulatory obligation that it has in fact addressed.
Let's, Peter, would you please read your proposed language or amendment slowly so we can get it up on the screen?
Sure. Agencies that have incorporated industrial standards by reference in their regulations should arrange to be notified by the adopting standards organizations of relevant revisions to those standards the organizations may have made, comma, and consider adoption of any such revisions.
Do we have that up correctly? Two members wish to be recognized, one of whom has real expertise on incorporation by reference. I'll start with Jack Bierman, and then I will turn to Emily Bremer. Jack?
Yeah, this language reads more like a recommendation than something in a preamble, and so I would.
Okay. Anything else?
Well, no, I'm in agreement with the spirit of it, but I think it's already captured by the recommendation in 4A, and I think maybe this ought to be written as preamble language, saying, for example, one place where there's change, and then give the example that Peter gives. I wouldn't hone in on this particular way that things change in this kind of language.
Emily?
So I agree that it would be appropriate in this recommendation to acknowledge this issue, but I would first of all cite the incorporation by reference recommendation, which has a whole chunk of recommendations about keeping incorporations up to date. And so I think referencing that prior work is probably the best way to ensure that we don't sort of accidentally preempt recommendations that were, I think, pretty thoughtfully drafted. And then I would also just modify the language not to refer to industrial standards, since that's not the terminology that we used in the incorporation by reference recommendation. I think standards by itself, anything, and using the full phrase incorporation by reference is probably preferable, but that is perhaps a matter for the Committee on Style.
And what is your thinking, Emily, on whether this should be preambular language or should it appear as an actual recommendation?
I don't know that I have a strong view on that. Given that we're adding this at this late stage, I think writing it in a way that would make it appropriate to add to the preamble, and I agree with Jack there that we shouldn't use recommendation language if we're going to add this to the preamble. I think we should probably just have a sentence in the preamble and written so as to be preambulatory text, if you will, with a reference to our prior recommendation.
Thank you, Emily. Hi, Feldblum, you'd like to be heard?
Yes, very brief comment. My reaction to the term industrial standard was to take out industrial, and I just want to say I don't think it's just stylistic, because I think of something like the Access Board that has standards on access for people with disabilities that are not themselves self-executing. Agencies have to refer to those, so I just want to make a point that I think that just saying standards is better.
I think there's consensus on that point. Peter, you have no objection to removing industrial, do you?
No objection to removing industrial. And since I can't make a motion and there are suggestions of preambular language, that's certainly better than not having nothing at all.
Let me turn to John Duffy, who seeks recognition. John?
It's not on this point, so maybe I should just wait until you resolve this point.
Good. We'll come back to you in a moment here. Peter, do you have any suggestion for Peter Strauss? Do you have a suggestion as to whether are you content with having this as preambular language rather than appearing as a recommendation?
Sure.
Emily, can we call this the Bremer Amendment here?
Yeah, sure, that's fine. I'm happy to move it.
And the amendment would be as it appears on the screen, subject to stylistic revisions by the Committee on Style. Kristen, do you want to be heard on this particular point, Kristen Hickman?
I was simply going to offer to move it as preambular language, but you beat me to it with Emily.
Okay.
I support the amendment to the preamble.
Or is there objection to the Bremer Amendment? Without objection, the Bremer Amendment is adopted, again, subject to revision by the Committee on Style, as everything else is, I suppose. Let's turn back to John Duffy. John?
Sure, thank you. My suggestion, or at least maybe I'd just like comment from the committee that wrote this, on 4D, which is that line 103 maybe? Yes, for 101 to 103. So I'm wondering why this document doesn't refer specifically to 553E petitions for rulemaking. Because I think that's an important way in which interested persons can try to prod an agency to do a review. And I have language, I mean, I think it fits within this, and you could say, well, it's sort of, generally encompassed within this, but a petition for rulemaking is a legal thing that the agency, as we know, has to respond to. And I think they should consider the existence of such things. And I think we should remind them by putting it in as a separate category of things that they should consider when they're deciding where to allocate their resources for periodic review. So I would, unless the committee has some strong answer to this or strong aversion to it, I'd say that one of the things in the list of things that should be considered are petitions for the modification or repeal of existing rules.
Are there any comments on John's suggestion? And I would, after hearing comments, would just want to maybe turn it over to Reeve to see if, or anyone else who remembers whether this would cause any tension with our recommendation on petitions for petitions that we issued several years ago. I don't think so, but
it seems to accord, as I recall, intents of that recommendation. No, I don't see it. I don't.
Jim, you have a comment on this point, Jim Tozy? Does anybody have are there any members have comments on John Duffy's suggestion?
I forgot, I didn't have my voice on. I think there's an overtone of, it's one thing to go for a review of a retrospective reg. People see that as a positive thing on both sides of the aisle. There's hardly any complaints that you shouldn't look at a rule in Mountain State where it's very difficult. Doesn't mean you shouldn't do it. It means it's difficult. Professor Weiner, when he said you look at separate ones like the standards, that's a separate package and it's very good. So it's seen as a positive light. But when you add to that the repeal of existing rules, different light on it, I think, historically on that. And I'm not sure I would mix up what I see as a very positive statement by the committee on retrospective review and using then, although analytically I agree they're very close as a repeal, it just might take outside this group in a little different light than I think it's intended.
Ron Cass is recognized. Ron?
I'm usually at my best when muted. With all respect to Jim's point, I think when you're looking at one sort of thing that may suggest a benefit from review is the fact that people are asking you to take a look at it. They're complaining about a regulation. Certainly that may be a reason, as John suggests, to add to the basis for reviewing the rule. So I certainly would favor including it in there. I'm sure we can massage the language in a way that won't trigger the reaction that Jim was having.
John?
So
John
so I tried to phrase this, and to make it concrete, I'd say right before or suggestions could be listed as another alternative. It just says petitions for the modification or repeal of existing rules. The key word in there to answer Jim's point is modification. This is not necessarily a deregulatory point if that's that it has sort of a political value. Somebody might petition for rulemaking and say, the existing rule should be modified, should be made much more aggressive in light of new evidence. And I think that that's certainly something that the agency should consider in deciding whether to engage in review of an antiquated rule.
So, John, how would you like the language here to read? How should we incorporate this suggestion?
So after the phrase requests for waivers or exemption, which I think would go in, would normally occur in adjudications, just say petitions for the modification or repeal of existing rules, which is, sort of the rulemaking version of a request for a waiver and exemption. A waiver and an exemption, I think, would usually come on a case-by-case, more adjudicative basis. A petition for the modification or repeal of existing rules is something that's covered as part of a 553 process. It's a rulemaking process.
Aaron, would you?
Yeah, so that's fine.
Aaron, would you like to be heard on this as the committee chair?
Yeah, we did not discuss this during the committee process. I think it's consistent with what we did discuss in the process and the rest of the itemized things on the list. We didn't talk about it during the process. I have no personal objection to it.
Is there any objection to the Duffy amendment represented on lines 101 through 102? Or without objection, it's adopted. Are there any additional proposed amendments from the floor? Hearing none, we'll move on to a vote on the recommendation. Is that correct, Reeve? All those in favor of adopting the recommendation, please say yay.
Yay.
Yay. Yay.
Opposed, nay. The yeas have it. and the recommendation is adopted. And thank you once again, Aaron, and thanks to our two consultants, Lori and Jonathan. And with that, we'll move on to the next recommendation. A little bit of ahead of schedule here. Just give me 1 second, please. Not till 2:30. We're going to take a 5-minute break, and we'll resume at 2:05. Everyone is now available, and we'll turn to the fourth recommendation on the agenda. Early input on regulatory alternatives, comes from the Committee on Regulation. For their work on the recommendation, I'd like to thank the committee's chair, Connor Rosso, and our two outstanding consultants, Christopher Kerrigan and Stuart Shapiro. We'll first hear from Stuart on the consultants' report, and then Connor on the committee's proceedings. Stuart?
Thank you, and thank you for the opportunity to work on this project. And a lot of people's help went into this project, including Keith Holman and the committee's important contributions as well. Our charge from ACUS was to examine how agencies solicit and consider early input in the rulemaking process, and how and whether they consider alternative regulatory options when formulating a regulation. The existing literature, reading it going into this project, gave us reason to be skeptical that agencies gave much weight to the alternatives to their selected policy. But the literature also only examined actual regulatory documents by and large. It was also quite old. Much of it dates from the 90s and even the 80s. In order to sort of update the literature and delve in more closely, we did three things. We reviewed the legal requirements for early consideration, for early consultation or consideration of alternatives, including requirements in NEPA, in SBREFA, and in other statutes. We reviewed 25 economically significant regulations, roughly evenly divided between the Obama and Trump administrations. And in this, we reviewed the proposed rule, the final rule, and the regulatory impact analyses associated with both rules. And then finally, we spoke to officials from 5 agencies, all of which engage in extensive notice and comment rulemaking. If we had just looked at the regulations, I think we largely would have reinforced the skepticism present in the academic literature on this subject. But the interviews revealed that there is actually a lot more extensive engagement with stakeholders before the NPRM stage, particularly for complex and novel regulations, and that agencies internally do consider regulatory alternatives often extensively. Some of these are done due to legal requirements like SBREFA, like negotiated rulemaking requirements, or the requirements for consultation in NEPA. But there are also processes that have been established by agencies over the years and have become norms within the agency for reaching out to stakeholder groups and for consideration of alternatives. It is true that they do not always document all of these consultations and consideration process in the regulatory documents, such as the proposed rule, or if they do, it's often in the regulatory impact analysis, which isn't always easy to find and not always done in the most transparent manner. Our recommendations thus were geared toward reconciling this difference between practice and the public-facing documents that agencies put out, and increasing agency transparency regarding both early consultations and alternative consideration. They're also geared toward the sharing of best practices because we found that there was many different styles of managing the early stages of rulemaking as there are agencies. To summarize, I think we identified the need for measures that would reward agencies for the transparent involvement of their stakeholders, the transparent consideration of alternatives, and the sharing of best practices.
Thank you, Stuart. Connor? Connor, you need to unmute yourself.
Sorry, I apologize. I just want to echo the thanks to Stuart and Chris for their excellent report and research. And thank you to the staff at ACUS for their hard work on this project as we work through the committee process. And I want to emphasize that these are very much committee recommendations and want to thank the committee for 2 days of very robust discussion of the recommendations. I'll just very briefly summarize a few aspects of the recommendations that I think benefited from the committee's consideration. First, we devoted some time to thinking about ensuring that our recommendations are consistent with the relevant regulatory review executive orders. And I think the recommendation reflects that. Second, we spent time thinking about weighing the costs and benefits of early feedback to agencies and trying to incorporate the importance of both sides of the cost and benefit ledger. Third, we thought about promoting transparency of these early pre-NPRM interactions to the extent possible, transparency. And then finally, we thought about encouraging agencies to solicit this early pre-NPRM feedback from traditionally underrepresented parties. And so I think the recommendation reflects the discussion on those 4 points. So with that as a very brief overview, I will turn this back over to Matt. And I look forward to hearing the conference's comments and thoughts on the recommendation.
Thank you, Connor. Are there any conference ACUS members who have general comments on the recommendation? None? All right, we'll turn to the manager's amendment. Is there any objection to adoption of the manager's amendment? Manager's amendments. Without objection, the manager's amendments are adopted. We have no council amendments on this recommendation. We do have a pre-submitted comment from Alan Morrison at line 31, and once we have that up, I'll turn it over to Alan.
Thank you, Matt. Alan Morrison, Senior Fellow. Who is the discussion supposed to be with? Or is it just discussing in some other place? I couldn't figure that out. I don't think it's a substantive objection so much as a question.
Connor, may I turn to you?
Yeah, I mean, I think, I don't know if we explicitly discussed this as a committee, but I think this means both internally and also with other agencies and in the NPRM. So it's sort of throughout the different processes and contexts in which this could be useful. All throughout.
Ron Cass?
Yeah, I think that Alan has helpfully raised a question here, and Connor's answer and Stuart's. I think we need to be a little more clear about whether this is a public discussion, a public consideration, if it's simply internal. I think whichever we mean, we ought to say more specifically here.
Alan, did you wish to be recognized again? I thought I heard you.
I did, but I think Ron has expressed my concern about the lack of fullness and response of Connor's response. So I think we should, discuss is an odd word. Maybe, and also report the extent of their outreach, or include in their final rule the extent of their outreach, or something like that. But if I were an agency, I wouldn't know what to do with this particular statement. To be sure, it's not in a recommendation, but they read the preamble too, and so it seems to me it ought to be clearer.
Nina Mendelson, did you have a suggestion? Nina?
Yeah, yes, I am suggesting assess as a possible alternative, because that suggests some internal consideration and maybe some outreach as well.
Ron?
Yeah, I think assess would be fine, except that the sentence that follows from it doesn't seem to fit with that. If all they're doing is assessing it, how does it demonstrate their seriousness? It sounds like we're trying to demonstrate something to the public in the second sentence there. I'm not sure that anything would be lost by eliminating the last two sentences of that paragraph, but I'm not recommending that without knowing what it is we actually are intending to do with those two sentences.
Connor, I think the only thing I can do is turn it back over to you.
Sorry, I keep getting remuted. I think what we were trying to do is, we have, Alan, I'm sorry you found the response unsatisfactory, but we have a recommendation about the agency sharing the material, the outreach internally. We have a recommendation, the final recommendation, agencies sharing it with each other. And we have a recommendation in the middle about agency incorporating pre-NPRM feedback into the NPRM. And so the idea is just sort of as a overview and preview of what's in the recommendations, and sort of a summary. And so maybe we could do something to the extent of discuss internally and assess in the notice of proposed rulemaking, or incorporate in the notice of proposed rulemaking, and sort of hit both points, because I think that's what we're trying to kind of preview is what's in the recommendation.
Matt, if I may,
Hold on, Alan, please.
Matt, I was further confused by the extent permitted by law. I mean, what law would not permit people to discuss things internally or talk to other agencies about it or tell the public what they did? So that's why I further thought maybe this was something else that they meant to say in this. And maybe Ron is right. I can't see footnote 12 on the screen right now, so I don't know what would be lost by taking footnote 12. Oh, it's just a citation to the book. Whether we need to preview that in there, but I haven't studied the recommendation with that degree of care. But I just came upon this sentence there, and it struck me as being not informative.
I could just briefly say, to the extent that certain information is provided the agency confidentially, the agency in consultation would want to respect that confidentiality, is one example.
Charlie Maresca, do you wish to be recognized?
Mute. I don't think it's, I'm not an expert on the independent agency rulemaking structures, but it's my understanding that at least some of them have some ex parte rules that limit discussion with outside groups, at least. I don't know about internally at early stages of rulemaking.
Ron Cass is recognized.
Yeah, I would recommend deleting those two sentences, because I think the more we discuss it, the more unclear it becomes. And since the recommendations themselves are fairly clear and pointed, I think we're better off eliminating a source of potential confusion. So I will recommend that if it's congenial to the committee, and move it if it is not.
Connor, do you wish to be heard on the Cass amendment? Chris Kerrigan also has a comment too, so in whichever order you prefer, Connor, let us know.
I'll just briefly say, I don't think it's critical at all. I think it's supposed to kind of be in the nature of a summary and overview, but I'd love to hear Chris's thoughts.
So we'll hear from Chris, and then Sid Shapiro seeks recognition. Chris, and then
Yeah, so
Sid.
I thought this was more around disclosure of those early discussions more than anything else, and previewing the recommendations in that regard, encouraging more disclosure in public documents of discussions agencies might have early in the process. So if I were to propose, I mean, eliminating is fine, but disclose would be something I would propose there.
So you would have this, you're suggesting that the sentence read what exactly? Agencies might also disclose the extent?
Yes, that's what my interpretation of what that second part of that paragraph was suggesting.
Sid?
The recommendations.
I have the same suggestion. I was going to say report on.
You're okay with disclose, though?
Oh, yes.
Turn back to Ron. Ron, what is your thoughts on these two sentences with the substitution of the word disclose?
That raises the question: disclose how and to whom? And again, I wouldn't want to try to draft language for that on the fly. I understand the instinct now better, but I'm not sure that we have a fix for it. So I would still stick with eliminating it.
Jack Bierman?
I think the idea, if I'm understanding it correctly, is that this would be disclosed in the notice of proposed rulemaking or some other subsequent document. So why not say, to the extent permitted by law, I think is important because it could involve ex parte communications or whatever. Agencies might also disclose in subsequent rulemaking documents the extent of their early rulemaking documents, the extent of their early outreach efforts, and so on. I think that to me that's a valuable thought, and the in a sense in a preamble.
Ron?
I don't have any objection to that.
Connor?
I think that's fine. I think in the committee we talked about emphasizing internal sharing of information, but I don't think it's critical to have that in the preamble. And I think this is clear, so I think that works fine.
Bill Funk, is your comment on this particular point?
Yes, it is.
Please.
And my only point is, it would seem to me this would include disclosing it in the rulemaking docket, as opposed to in the Federal Register in the preamble or final rule or something or other. So if that's, I'm saying that would be included. I'm not saying to add that. I'm saying subsequent rulemaking documents would seem to me to include the rulemaking docket. If you want to say that's only the only place you have to put it, then this language is fine. But if you meant put it in some publicly put out there in the Federal Register or on the website or whatever, then I don't know if this language is sufficient.
Allison, you seem to have a comment in the chat feature. Do you wish to be recognized?
Yeah, I understand that in ex parte discussions, it's possible, or even in submitted comments, it's possible that someone submits information for which they request confidentiality or even that is properly confidential. But I don't understand how disclosure of the extent of outreach or the process for selecting among various alternatives could possibly be barred or not permitted by law. And I'm concerned that this sentence suggests that there are times in which the law bars agencies from disclosing outreach efforts or disclosing the process for choosing among alternatives. And I don't think there is any such law. I think it would be bizarre for us to suggest that the type of information specified in this sentence would be barred from disclosure.
Any response to Allison's comment?
I think we addressed the point elsewhere, so I don't think it's critical to put it in here.
Are we back to Ron Cass's amendment to strike the two sentences?
Yes.
Don Elliott, you have a comment on a different aspect of the recommendation? The Cass amendment would strike the last two sentences of the paragraph. Is there any objection to the Cass amendment? Without objection, the Cass amendment is adopted and those two sentences are stricken. And now we'll turn to Don Elliott.
Yes, thank you very much. I had a concern, and you may have already passed this. If so, I apologize. I just noticed it. We do, in the recommendation, mention advisory committees, and we also in the recommendation talk about meetings with stakeholders on both an ad hoc and a regular basis. What we don't do, and maybe it's appropriate to do it in the preamble, is cite to the Advisory Committee Act and alert agencies that if they get advice on the final product from a group that meets multiple times, it can become an unchartered federal advisory committee. So I'm not suggesting any big deal or an extensive discussion, but just where we talk about meetings on a regular basis, maybe we can either cite to a case or simply cite to the statute and some of the interpretations. But that was one of the big issues that we confronted when I was at EPA, is making sure that when we had meetings with stakeholders, they didn't unintentionally trigger the Federal Advisory Committee Act.
What would you propose, Don, by way of amendment here?
That when we talk in the recommendation, and you keep moving it, but when you talk in the recommendation about meetings on a regular basis, then I think we should drop a footnote saying for the potential applicability of the Advisory Committee Act, and then a citation in such circumstances, C, and then I leave it to the Committee on Style or the staff to find some of the cases that have made this issue. There was one involving Hillary Clinton's recommendations on healthcare, for example, which was one of the famous ones.
Can we put that language up on the screen, Mark, somewhere? Is there a particular line, Don?
Yeah, I'm working on that. I'm trying to, yeah, in the original at line 69, it says in determining what outreach, methods of public input, including meetings with interested parties held regularly or as needed basis on rulemaking activities. And after the words held regularly, I would suggest a footnote that notes
Don, you are running into our rule against footnotes in the recommendation.
Okay.
Held pretty firm on. I don't know if there's an alternative here. Can we put in a parenthetical phrase?
Sure, we can do a parenthetical phrase. Meetings with interested parties held regularly, comma, which may trigger the Advisory Committee Act, paren close. Or I guess grammatically it should be meetings with interested persons held regularly. And then I think, yeah, it's appropriate to say which rather than that. which may, under some circumstances, trigger the Advisory Committee Act and then a citation.
Connor, you have a thought on this, on Don's suggestion?
I don't have a strong objection. I just say we don't sort of call out other specific legal requirements that may apply in other cases. So it's a little bit inconsistent with the fact that we don't do this everywhere else. So I guess I have a mild preference against adding it for that reason, but I don't feel strongly.
Jack Bierman? Hold on.
I just want to note that advisory
just hold-
committee.
Jack, just hold on. Alice Kottmeyer, what is your issue? Alice, did you have a comment? Okay, Jack Bierman.
I think Alice said she put in the chat that it's called the Federal Advisory
Yeah,
Committee.
we know, Jack.
Yeah,
we know what it's called.
But E already says advisory committees. This is redundant.
Don?
Yes, going both to the most recent comment about the redundancy and the and Connor's good comment that we don't discuss ancillary legal requirements in other areas. My concern is that we list as alternatives A, meetings with interested parties held regularly, and then in E, advisory committees. And I think that by listing them separately, we wrongly imply to agencies that they can have meetings with interested parties, hold them regularly, and not comply with the Federal Advisory Committee Act. And so I just think we have to be careful not to appear to give erroneous advice. Another alternative, but I guess it involves, well, I guess you could do it as a parenthetical, is you could cite the Advisory Committee Act in E, and that might help. It doesn't really alert agencies to the potential pitfall, but at least it lets them know that there is regulation in the area, and presumably once they do that, they can research it and discover the problem themselves.
Alan Morrison is recognized, and then Ron Cass is recognized.
Yeah, this is not the time or place to debate what the technical requirements of the Federal Advisory Committee Act are. I don't think Don is right that and the Hillary Clinton case was largely overturned, but it does seem to me if we're going to mention the Advisory Committee Act, it doesn't belong in a parenthetical in the recommendation. It could be something could be mentioned to it about it in the preamble if anything is needed at all. But I don't think anybody's going to be confused with when we talked about advisory committees in E. I mean, the other thing you could do, of course, is you put E as the first one, and then make it to be clear that that would be the first consideration. But it certainly doesn't belong in a parenthetical in a recommendation. But thank you, Matt, for preserving the no footnotes in the recommendation rules.
I take Alan Morrison's point. I think he makes a good point. I think some reference to this in the preamble would be helpful, even in a footnote. But I do agree with Alan; it belongs in the preamble rather than in the text.
Ron Cass.
I think it may be better to have meetings with interested persons held episodically or as needed, and that way it doesn't look like it's the regularly triggers the concern about the advisory committee, and we can insert a comment or a footnote in the preamble if we want. But I think that would avoid the problem that Don was worried about without triggering the other problems, and without
that would be fine with me. That would be fine with me.
Is there any objection to the inclusion of the word episodically on line 69? All right, without objection, we'll include episodically after held in line 69.
And also reference the problem in the preamble. I think that was also part of Ron's recommendation.
And specifically how and where?
just describe that the Federal Advisory Committee Act may be applicable, and then describe the terms of it. That if a group more than a certain number of members meets on a regular basis and provides advice to the agency, it may trigger the Federal Advisory Committee Act. That's on the face of the Federal Advisory Committee Act. So it's just basically summarizing what it does.
Jack Bierman?
Yeah, I think it would be better just to end the phrase with meetings with interested persons. The agency.
Where are you, Jack? Just where are you here?
Oh, I'm sorry, in 2A. Why not just end with meetings with interested persons, and then let the agency decide whether they're going to do it on a regular basis or as needed?
No, that's, let's go back to the preamble. I think we've already voted on this, have we not?
Okay.
Does what do you think, Reeve? Let's go back to the preamble.
Okay.
Let's go back to the preamble here. Don, you need to tell us where you're proposing language.
Okay. Well, give me just a second. Come back to me.
Okay. Are there any other amendments from the floor that you'd like to have considered?
Matt, I'm ready to suggest a place for you if you're ready.
Please.
I suggest that at line 36 in the original version that was circulated begins a paragraph. Nevertheless, seeking early input on alternatives may not be appropriate in all cases. And then I would add to the text of the preamble, and may trigger certain procedural requirements. And then in a footnote, just say, see Federal Advisory Committee Act and a citation.
Ron Cass, your view on that suggestion?
I'm fine with the suggestion.
Connor, let me turn to you and just ask if you have any concerns with Don's suggestion.
No, I think that's fine.
May I ask Ron to move it as a Cass amendment? Because Don is a senior fellow and can't move an amendment.
So moved.
Any objection to the Cass amendment reflected in lines 36 through 37? Without objection, the Cass amendment is adopted. All right. Jack, did you have some additional amendments on this recommendation? And if so, the floor is yours.
Thanks. I had one thing in it, but it starts with a question, which is, it seemed to me that there was no, in the recommendation section, there was no blanket statement of the council recommending that agencies do this. So I thought that it would be, unless I'm missing something, which the people, the consultant and the committee can tell me, I would recommend inserting before recommendation 1, a new recommendation 1 that says agencies should consider, in light of the benefits and costs of doing so, whether to seek early input concerning regulatory alternatives prior to issuing a notice of proposed rulemaking on important issues. And I get that language out of the preamble, and then renumbering the rest of them. But it just seemed to me that it jumps in the middle, the way it's written now. And I think the main thrust is we want to encourage agencies to do this.
Let's hear from Connor first on this, if you have an opinion.
Well, I mean, we want to be sensitive that the recommendation, is adding to the amount of work that agencies have. And so I think we tried to address this point in recommendation 1 by providing a number of factors. And so the idea is, to the extent these factors in 1 are satisfied, then it would cut in favor, old 1, now 2 is renumbered, would cut in favor of the agency doing this, but we didn't want a blanket statement encouraging it, given the amount of additional work that agencies would have to do if they were to do this across the board.
Jack, any response?
Well, I mean, I think my statement encompasses everything that Connor just said. It says in light of they should consider whether to do it in light of the benefits and costs of doing so. So that's sort of the global, because then you start saying when determining. It just seemed to me, I mean, if the committee doesn't like it, then I'm happy to withdraw the proposal. But it seemed to me to be just a simple matter of form that would capture the, more generally, and then get into the specifics after that.
Does anybody else wish to be heard on Jack Bierman's amendment on line 46? You want me to put it up for a vote, Jack?
Yeah, I can't read the silence, especially in a room on Zoom. It's hard for me to read the silence, whether whether people are agreeing or disagreeing or don't care.
All those in favor of the Bierman amendment, please say yay.
Yay.
Yay. Yay.
Yay.
Opposed? Nay?
Nay.
Hey,
Yay.
Try it one more time. All in favor, yay.
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 Yay. Opposed, nay?
Nay.
Yay.
Do we need a recorded vote?
I'm happy to withdraw the proposal, Matt, if that makes life simpler, if that's possible, parliamentarily speaking.
I have no objection. All right, the Bierman amendment is withdrawn. There any other Jack, did you have any other amendments?
No, the other things are stylistic, and I'll just submit them in writing to the Committee on Style.
Okay, are there any other amendments to this recommendation, proposed amendments? If not, we'll turn to a vote on the entire recommendation. All those in favor of adopting the recommendation say yay.
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 Opposed, nay. The yeas have it, and the recommendation is adopted. Thank you again, Connor, and thank you to our consultants as well, Chris and Stuart. What we will do now is before moving on to the last recommendation, we'll take a 5-minute break just to make sure that we have everything in order on our side with the consultants and so forth. And so we'll see you at, let's say 2:50. We'll resume at 2:50. Thank you. Welcome back. We'll turn to the 5th and final recommendation of the day, titled Virtual Hearings and Agency Adjudication. This comes to us, not surprisingly, from the Committee on Adjudication. I'd like to thank the committee's chair, Nadine Mancini, as well as our consultant, Fred Lederer of the Center for Court and Legal Technology at William and Mary Law School. And I should also thank our Principal Deputy Research Director, Jeremy Grayboys, whose report from last year on virtual hearings contributed to the committee's deliberations on this recommendation. We'll hear first from Fred on his report, and then any comments Jeremy may want to add after that, and then we'll hear from Nadine on the committee's proceedings. Fred, welcome back to ACUS.
Thank you. It's always a pleasure. So, ladies and gentlemen, I'll be brief. What we found, as I believe you all know, is a unanimous view, and by the way, at least in my experience, that's rather rare, that the virtual hearings that have been conducted this past year have been useful. They were and are, as was often expressed, a useful tool in the toolbox of adjudicators. And in appropriate cases, they should be continued past the pandemic, and of course, the key word is appropriate there. Now, it's not that they have been trouble-free. Almost always, when I had the opportunity to speak to adjudicators, there would be discussion of what was often called glitches, which usually referred to internet issues, loss of bandwidth at one time or the other. And forgive me for perhaps stepping outside of my role, I believe the agencies deserve enormous credit for the incredible effort they've put into continuing remote appearances and hearings remotely, because to make them work, they largely had to take staff members, particularly lawyer staff members, and assign them the additional duties of going ahead and preparing in advance, working with the litigants, the claimants, the counsel, and so on, all of which has worked amazingly well. So it's not that the matter has been trouble-free, but overall it has worked well. As the recommendation points out, this potentially extends access to justice on the part of individuals who might not otherwise be able to appear before a hearing. It goes ahead and permits those agencies whose judges are frequently on the road, often without access to their own hearing rooms, to enhance their operations. As I've thought about this, realizing that you all know this, and I don't want to waste any of your time, I just thought it might be worth a different way of looking at this for a brief moment. Earlier this morning, I had need to conduct 2 separate video conversations. One with an individual in South Korea and one with an individual in China. The South Korean conversation was magnificent, no technical issues at all. The one with our person in China didn't go quite so well. And I was thinking of the adjudicators with the glitches, because we had bandwidth issues. But when all was said and done, it worked. I accomplished the goals. And I think that's what the experience of the agencies have been. It's often very, very good. Sometimes it's not quite so good, but overall, they've accomplished their goals. And that's the background of the report, and I think the recommendation.
Well, thank you, Fred. We're very grateful to have your time and talent on this recommendation. Nadine, I'll turn it over to you for anything you wish to say about the committee's proceedings.
Thanks, Matt. Can you hear me okay? Yeah, that's good. Just a few comments. As you may know, if you've looked at the report and the recommendations, this recommendation builds on 2 prior ones addressing this topic, both of which came through the adjudication committee. And yet I find that this is a familiar project, but it's both new and timely. Obviously, as Fred's alluded to, the past 18 months have obviously required adjudicative agencies to find ways to do their in-person work remotely. This could extend from settlement conferences to pre-hearing conferences to hearings themselves. That this shift was initiated by an outside force that no agency could have anticipated or could ignore, made this experience an equitable one. In-person adjudication simply could not happen for anyone. So there are some agencies that were already well acquainted with virtual hearings, while others really had to dive in feet first. And I'm heartened to hear Fred say that he believes they've done a fine job. It makes good sense, therefore, for ACUS to see what lessons have emerged from this time. Oops. Okay. So this recommendation captures some of those lessons by identifying issues that agencies should consider in weighing what the future landscape of virtual adjudication might look like. The adjudication committee met twice this spring to discuss the recommendation, and there are a few areas that I think are worth highlighting from our deliberation. First, the committee weighed how virtual hearings can impact the communities that agencies serve. Fred alluded to this already. On the one hand, eliminating the need for travel can make access easier for those lacking the means or ability to do so. On the other hand, access to technology for some communities can be limited, and participants require appropriate devices and internet services that are capable of effectively using virtual meeting tools like Zoom. Second, we recognize that agencies need to stay apprised of new technological developments in this area and provide their participants in the virtual hearings adjudicators, parties, representatives, witnesses with adequate technical and administrative support in the use of these tools. This can mean real-time access to IT staff for troubleshooting during a virtual hearing, as well as training for adjudicators. Third, we considered when and how virtual hearings should be made available to the public. And then there's the implications that are both legal and practical of agencies recording virtual hearings and storing them. This could mean establishing a protocol for securing the information presented at the hearing and then protecting against misuse. Finally, we were cognizant of the need for agencies to assess how procedural fairness or substantial outcomes may be impacted by virtual hearings versus traditional in-person hearings. This can mean, for instance, gathering feedback from participants and then assessing how the different formats are perceived. I just want to thank Fred for his fine work on this topic, and to Jeremy as well as all of the ACUS staff who continue to provide incredible support for us at the committee. And I do especially want to thank my fellow committee members who are truly dedicated to this good work, and they always come to the table with open minds and thoughtful input, so I thank them for that. With that, I'll turn this back over to Matt.
Thank you, Nadine. Well said. We'll turn to the manager's amendment first. Is there any objection to adopting the manager's amendment? Without objection, the manager's amendment is adopted. Is there any general discussion on this recommendation?
Yeah.
Paul Verkyle.
Can you hear me? Okay.
We hear two of you.
Yeah. Is that better? Paul has two things open. He has multiple layers open.
Do you have a...
Paul, turn off your speaker. Turn off your speaker while you're speaking.
Turn off.
Paul, do you have a phone? Do you have a phone on?
Excuse me, I think Paul has two open connections, and that's what the problem is.
Paul, unmute yourself and see how that works.
That okay? It's okay? Wait a second. All right, let's try this.
Well, you have to turn off one of your connections.
I just did, I think.
Oh, there you go.
Are you okay now?
Paul, you're recognized.
All right, can you hear me okay?
Yes.
All right, sorry to mess up like that. But and I want to congratulate the committee, but I have, having been there when 10 years ago now, when we did our first recommendation in 2011, which Fred worked on as well, to good effect. I don't think we've moved the ball very far on this one. And so my concern is a friendly concern to say, this is a fence-sitting recommendation. It's almost repeating things we said 10 years ago. And it's not really encouraging agencies to take the step. It's a warning again of all the pitfalls. And if I'm an agency head looking at all those pitfalls and someone, right person comes from my office and says, let's do it, I'm saying, well, what about all these problems? So I, in a way, I don't know how to fix it necessarily, but I wish we could come out with a more positive statement on the importance of visual hearings. And certain things we could have added. For example, the federal court is now doing hybrid hearings, and I don't know that we researched all of that. We could have put that up. We are also looking at what about the Social Security disability? back when Fred started, they were doing 20% by virtual hearings. And I'll bet the number, maybe I'm wrong, it's probably up over a third now. And they're having good effect. And I bet you could not only get their results, but also quantify the savings. In my analysis, I think you could talk about virtual hearings saving agency budgets in the magnitude not far off what we did with the inflation adjustment recommendation, which is our biggest seller so far. I think there's a lot to be gained here, and I worry that we haven't gone far enough.
Thank you, Paul. Any additional comments by way of response to Paul or otherwise? Kai Feldblum.
So I want to agree with the fact that there are a lot of pluses, right, with virtual hearings. And I remember working on that in the first report. But I think, Paul, what we have now seen by this pilot project that has been a universal pilot project, that there are also some issues that we want agencies to learn from. Plus, and Fred, I would turn it over to you. I know that we talked a lot about the fact that there's a difference in terms of some of the hearings that we were talking about. And I know we had some language to explain that. So I don't see this, Paul, as walking away at all from saying, here are the positive aspects. I see this as allowing the head of the agency to say to the person who walks in and says, I don't like doing this, to say, excuse me, we've been doing it for a year and a half, and here are some positive things. But especially for people with disabilities that often have trouble with the virtual format, or for other reasons, people feeling they are not getting their point across as well, I think it's important that the recommendation says, if you're going to decide not to allow people to be in person and you're going to require them to do it virtually, you need to explain why. Because I do want agencies to be thinking about that.
Further comments on the recommendation? Why don't we turn to the first council amendment then? Council Amendment 1 appears on line 47. It adds to public library, quote, or other conveniently located governmental facility. Nadine, is that of any concern to you? Or do you otherwise have a comment on that proposal?
It's not. I think the idea is there may be other agencies willing to share space and or equipment. So I think it's fine.
Okay, and then there's a corresponding change, which is part of Council Amendment 1 at lines 200 through 201. It would similarly add the same phrase. Is there any objection to Council Amendment number 1? Without objection, Council Amendment number 1 is adopted. Let's move to Council Amendment number 2. Jeremy, can I turn to you to speak to Council Amendment number 2? I realize you're not on the council, but you did assist with drafting this amendment, and as I understand it, and we can ask Nadine in a moment if this is true, it accords with the discussion in the committee.
Sure, I'm happy to address that, Matt. The recommendation, as both Fred and Nadine laid out, lays out the positives for certain communities in favor of virtual hearings, as well as potential barriers to access for members of other communities. The recommendation further down lays out those communities members of whom may have difficulty with virtual hearings. It was noted that there was no corresponding section identifying groups for whom virtual hearings may actually improve access to justice. this paragraph attempts to lay those groups out.
Nadine, on this council amendment, your thoughts?
I think it is, as you said, reflective of the committee's discussions on these points. I actually appreciate the detail that's been added to the extent that it wasn't clear before, but this is exactly in line with what we discussed. So I'm fine with that.
I'm sorry. Were you finished, Nadine? I'm sorry.
Done.
Did anybody else wish to be heard on the council amendment number 2? Is there any objection to council amendment number 2? Without objection, it's adopted. Now we'll turn to council amendment number 3. Council amendment number 3 takes us to lines 113 through 114 of the preamble, and it simply provides that the recommendation provides for best practices, which I believe to be consistent with prior ACUS recommendations. Nadine, do you have any thoughts on this recommendation?
I don't, other than to note what you just said, which is it's the same language we used for the 2 prior recommendations. I think the practical guidance was to kind of maybe raise the bar a little higher, that, you know, this is really, we're expecting more agencies who have done it for the past 18 months might need some helpful guidance. I suppose it's a little bit of best practices too. I really don't have a strong objection one way or the other on it.
Is there any objection to council amendment number 3? Without objection, council amendment number 3 is adopted. Now we'll move to council amendment number 4, which is the final pre-submitted amendment. Lines 261 through 63. I will take this in the first instance, and then Ron or other council members may have something to say. The recommendation as it came from the committee simply refers to methodological challenges without specifying precisely what they are. This recommendation specifies what they are. This amendment specifies what they are in a way that I think is consistent with earlier ACUS recommendations on video hearings. Nadine, Ron, did you have anything further to say on this, or shall we turn it over to Nadine?
I'm happy to turn it over to Nadine. I would just add that having participated in a number of different hearings, not government hearings, but arbitration hearings over the course of the pandemic, there are differences, and there are subtle differences that are hard to identify, including the degree to which the people who are communicating are really reading each other the same way you would if you were physically present. So while I don't know how that will affect the evaluation of outcomes, I think it's something worth flagging.
Nadine, anything further on this?
No, I think it's fine. It echoes the language that's in the first line of that paragraph. To the extent it makes it more precise or clear, I think it's fine.
Are there any objections to council amendment number 4? Without objection, council amendment number 4 is adopted. Are there any additional amendments from the floor?
Yes, can I raise one?
John Duffy, please.
Thank you. Could we go to line 213, please? So I would suggest adding at the end of this will be taken to remedy the problem while preserving participants' hearing rights. And the thought behind this, it's, I think, quite intuitive, is that sometimes when you have a hiccup, like we just had actually with Paul Verkeil's 2 screens and we couldn't hear him, it may take a minute or 2. And that a lot of hearings are timed. A lot of hearings have time limits on them and other constraints. And I think that if the the basic thought behind this is that the remedy shouldn't prejudice the hearing rights. In other words, the technical hiccups that we know are going to happen in these things should be to the maximum extent possible, not prejudicing participants' hearing rights. So that's a thought. I think it's intuitive. Probably everybody assumes it's there, but I think it's worth noting.
Nadine, do you have a response to John Duffy's proposed amendment?
I would agree that I thought it was intuitive, but I think Ron Cass taught us earlier, if we can say it, we should say it. So I'm fine with it.
Is there any objection to John Duffy's amendment? All right, without objection, John Duffy's amendment is adopted and lines 214 is amended accordingly. Are there any additional amendments from the floor? Keep them coming. Ron Cass, do you still have a comment?
Yes, my only comment was on John Duffy's observation about there being two Paul Verkyles. I didn't think that was a technical problem. I thought it was just an indication that we value Paul that much.
Well,
We do
I
indeed.
appreciate that. May I just say thank you, Ron, for that, and turning a positive tone to my position, which I basically undermined by not being able to express it by video. But I do think we are moving in a good direction there. Thank you.
Alan Morrison, did you wish to be recognized?
Only to say that I thought Paul made an interesting point, and I didn't hear a response from the committee or from the consultants about going only halfway, as Paul, or maybe even less than that, as Paul would put it. There may be a reason why we can't go anymore, but Paul did seem to make a point. And if this recommendation had been issued in December of 2019 before the pandemic, I might have felt a little differently, and Paul might not have been made this point, but we certainly should have learned a lot. I know even just from things like teaching, I've learned a lot from the pandemic and feel more comfortable doing it than I certainly did before. So could we have a response, do you think, Matt?
Well, I'm not going to compel anyone to speak, but if Nadine wishes,
okay, you could ask for it, though.
If Nadine wishes to speak, or Fred wishes to speak, or Jeremy wishes to speak, or anyone else wishes to speak, now would be a good time.
I can jump in very quickly.
Please, Nadine.
Obviously have a great deal of respect for Paul's wisdom on this topic, having been there from the start on the two prior recommendations. I can only say that I don't think the committee viewed this as a halfway. And I also think that much of what we're seeing in the recommendation is going to be viewed through a completely different lens based on the past 18 months. Agencies have had a varied experience with, trying to be nimble and continue their work to do their mission. And I think that all of this will give them more, feedback that they can consider, guidance. I go back to the practical guidance. I do think that more agencies will be in a different position than they were with the two prior recommendations. So I guess I don't see it as a weak step forward.
If I might,
please,
I'm
Fred.
not in a position to make a substantive comment, if you will, on the recommendation. I leave that to Nadine and the committee. But my own view is we are still learning a great deal. I have just concluded our annual meeting of the state, federal, and Canadian courts that we support, and they all want to continue using virtual proceedings, and again, in appropriate circumstances. And the word appropriate needs some experience there. I have viewed this as a positive matter, and I am frankly hopeful that there'll be more work being done based on what we're going to learn in the next few months in particular, and in the next year or so.
Thank you, Fred. Before turning it over to Kai Feldblum, I'm wondering, Jeremy, if you could say something about the Social Security Administration's rulemaking on video hearings. which postdated the ACUS recommendation on the subject by a number of years. It was obviously quite controversial. Could you say a word or two about that?
Absolutely. And just to sort of echo what Hai said earlier, I think it makes sense in this area to proceed modestly and incrementally, because while this holds great promise, there are also significant technical and logistical challenges involved. What you saw with the Social Security Administration's rulemaking a number of years ago was an effort to remove currently Social Security rules have an opt-out where there is an affirmative opt-out on the behalf of claimants where they can say, I do not wish to have a remote hearing. The proposal was to remove that opt-out and allow the agency to determine the most efficient or most effective manner of appearing in an ALJ hearing. That met with significant resistance from various stakeholder groups, including representatives and certain adjudicators. There are deeply held views in this area. There is by no means a consensus around when video hearings are best used. So I do think proceeding modestly and incrementally in this area makes sense to get everyone's viewpoints.
Commissioner Feldblum.
So, Alan, I'm sorry if the response that I made right after Paul talked was not clear, because I thought it was very important to respond. So let me say two things. Number one, as I referenced, and I was trying, Fred, to turn it over to you, if you look at lines 22 to 36 of the preamble, we reference to the fact that the committee issued those recommendations about video hearings, right? And we really were maybe more ahead of the game. We noted that most video participants appeared in formal hearing rooms equipped with professional grade video screens, cameras, microphones, speakers, and recording systems. And because they were usually located in government facilities, you could have staff on site to assist participants troubleshoot. It would have been someone in Paul's living room, right next to Paul. Okay, and so this recommendation calls those a traditional video hearing. And then we have this new term for this recommendation called virtual hearings. And these are, and this was because of the pandemic, they couldn't come to a government office. Participants appear using their own technology, personal computers, tablets, smartphones, a location of their choosing, right? Their own home, the public library now, somewhere else. And those raise some particular other issues, okay? So this really is pushing it to the next level, because it is about a hearing in which you can stay in your own room, in your own home, not one where you went to a government agency close to you and then the adjudicator was in another city. Once we now have a lot more information, thank goodness. That's why I said before we might have recommended pilot projects. Well, guess what? We've had a huge pilot project, and agencies have seen the utility. So for those judges that said, oh my God, I have to see people in person. Well, maybe you don't. Maybe that person has a disability that makes it easier for them to be at home. And we're not we're still letting agencies choose whether to require it, but we're just recommending here that they think about it. But then there were also difficulties for people. So this is why I started, Paul, with saying, oh my God, I completely agree with your point of let's keep moving forward. I think this absolutely moves forward with some understanding of the nuances.
Thank you. Bill Funk, did you have a comment?
Oh, sorry.
Bill Funk, did you have a comment?
Yes, trying to take account of Paul's position and taking account of Chai's comments, I would suggest on line 43, right after we talk about the recent experiences, putting something like those experiences demonstrated that many of the reasons for agency reluctance to use virtual hearings were not as important as had been thought. In other words, we've moved forward. And this is sort of saying, we used to think there were a lot of problems, and yeah, there still are some problems, but they may not all be as important as we had thought.
Let me turn to Nadine for any reaction she has to Bill Funk's suggestion.
I think that would be fine. I mean, I do think that a lot of this is being looked at, will be looked at, and at least from our deliberations, we're looked at through the idea, the lens of the past 18 months, and that agencies now have experience that they may not have otherwise had. And so I would agree with Bill that, you know, I certainly knew adjudicators who wouldn't have tried this for any reason, and were forced to be able to do the work of the agency.
Thank you, Nadine.
I think it's fine.
Go ahead. I'm sorry.
No, that's it.
Jack Bierman.
Hi, I'm on the committee on this, and I raised this issue a little bit during the committee's deliberations, but not much. And I apologize, but my internet went haywire when Paul started speaking, so I actually didn't hear what he said, but I'm getting the gist from the later things. But I also think that the social science research that's been coming out recently seems to show that people are very, very bad at making credibility determinations and detecting truth and lying by personally observing people, and that actually we'd be probably better off making those determinations based only on objective factors. So I'm wondering whether we're going to get the next step is not going to be expanded use of virtual hearings, but a reassessment of whether human decision makers deciding cases based on the credibility of people that appear before them are actually worse than we could do without those hearings. That's a little bit off the topic, but something I think people ought to be thinking about.
Thank you. And Dick Pierce has some thoughts on that we can that he's put in writing. Ron Cass is recognized.
Well, I'm not sure Jack's comment is off topic, because the insert that Bill Funk suggested, and it may be right, but it may also be only one side of the equation. So it may be that to the extent that people do try to make credibility determinations, they make them better in person, however badly they make them, than they make them remotely. And the opposite may also be true. They may make them better remotely than they make them in person. I don't know the answer to the question, and I'm not sure that we can draw a conclusion at this point. The one thing I can say with certainty that we've learned during the pandemic is that for people who get up during a hearing, pants are a very important feature.
Jack, did I understand you to be drawing a distinction for purposes of credibility determinations between in-person and virtual, or were you making a more general point about the role of credibility determinations in adjudication?
Yeah, I was making a more general point that actually the ability of the adjudicator to observe the demeanor of the witnesses or the claimant or whatever it is may actually, the more they can observe, the worse they may be at making the decisions in terms of research. So that, it just means that the next step may be, I doubt it would actually happen, but the next step, if we actually believe in the research, may be to not be so concerned about the ability of people to present themselves in front of the person. If the question is truth, if the question is satisfying people's emotional need to be heard and the dignity of that, that's another question.
Oh, right.
Does anyone else wish to be heard on Bill Funk's suggestion that we add this sentence at lines 43 through 45? Is there a voting member who wishes to move an amendment? Bill Funk cannot move an amendment.
I'll move the amendment, if that's okay.
Is there any objection to the Duffy amendment?
Matt, excuse me, it's Nadine. I see Judge McCarthy has a comment. He's raised his hand. I know we wanted.
Well, is it on this particular amendment, Judge McCarthy?
It is. I just wanted to kind of echo Chai's statements. And from my participation on the committee, we were trying to thread the needle between the benefits and the drawbacks without passing upon what the experience would ultimately be. And I think that the Duffy Amendment suggests tipping the scale towards a pro stance for virtual hearings that the committee didn't want to go that far. And with regard to Jack's comment about credibility, I think that was primarily based on demeanor. And of course, the adjudicators can take many other factors into account. So I, as a committee member, I'm kind of opposed to tipping the scale. We tried to keep it objective and even keeled. And I think that Ron Cass made a good point that we don't quite know yet where we're going to come out. So we viewed these hearings more as a hybrid type approach in various circumstances. That's all I have to say.
Before turning to others, let me just ask a question. Is important in line 44 the correct word here? I think probably, this is not the greatest word, but I think weighty or something like that is probably what was intended here. Important is, I don't think is the right word. Does anybody have an alternative before we move on to hear other comments? Well, hold on, Renee. Hold on.
Yeah.
Just bear with me for a sec. Do you have a comment on this? Do you have a comment on the word weighty?
I do. I was going to sort of make a change to the sentence generally that might help with the issue you're trying to address.
Okay. Why don't you offer your suggestion?
Okay. So I would say those experiences demonstrated that some of the reasons for the agency's reluctance for using those hearings, were not, I don't know. Then I lost traction, but I think the word some helps alleviate some of the thumb on the scale problem that others might have been objecting to. Or that some of the agency's reluctance for using these hearings, were not realized or something like that.
Clyde Feldblum, you're recognized.
So as a member of the committee as well, I want to align myself with what Judge McCarthy said. I understand a sentence like this being written in response to this immediate conversation, but the fact is, I think all the way through, we were being very careful to say, hey, some of these problems were not really as big of a problem, but then there were other issues that came up. So I would suggest that this is not particularly helpful for the reasons that Judge McCarthy said, and if others agree, maybe just be able to withdraw that as opposed to having to vote on it. But I think we have in the preamble already a sense that this sentence is trying to capture.
Okay, we'll hear next from Michael Hertz, and then we'll hear from Ron Cass. Michael?
So underlying this is really just the state of the technology. And what we have learned is one can't talk in the abstract about virtual hearings or reasons to be for or against virtual hearings without knowing something about the technology. And in 40 years from now, when holograms are perfected, virtual hearings will be exactly the same as in-person hearings. And this, ACUS will completely endorse them. Unnecessarily, because everyone will be doing them. And so one way around the problem here, the reasons don't change. The reasons for objecting are valid in the abstract. But as technology improves, they become less compelling. And so maybe the way to phrase this is to say, those experiences demonstrated that recent technological improvements allow further or continued expansion or continued reliance on virtual hearings, or open up additional opportunities for virtual hearings. Not saying how much, but just saying that, we now realize the technology is a lot better than it was 10 years ago, and we can do more.
Ron Cass. Thank you, Michael.
I don't disagree with anything Michael just said. And I agree with Renee that the word some, when she was putting that in, helps. I'm just not sure I see the need for the sentence, because the next two paragraphs go on to talk about the benefits and advantages of virtual hearings. And then the whole report seems to me to be a balanced discussion of both benefits and drawbacks of virtual hearings as we have them now. And I think adding a sentence in here, however much we try to wordsmith it on the floor, will have the effect of detracting from the balance in the rest of the presentation that follows. So I would reject the amendment.
Anything further on this point?
Matt, it's Nadine. I think Ron's point is well taken, as well as the committee members who've expressed some concerns there.
That's so. If there's significant opposition, since I wasn't the originator of this amendment, I'll withdraw it. And if somebody else wants to move it, I think Michael Hertz was going in a good direction, but I think maybe the wordsmithing is just, the game isn't worth the candle at this point. So I'll withdraw the amendment. If somebody else can pick up the mantle of lead the charge.
Are there any other amendments on this recommendation that any voting member wishes to offer?
So,
John?
So if we go to line 127, which is the very beginning of this, I think this is just worth a minute of discussion. When Paul Verkyle originally made his comment, I went here and thought, I wasn't sure why he wasn't thinking this recommendation was pushing, because it says agencies should offer virtual hearings. There's some caveats, but that's a very strong recommendation, I thought. I do think that on line 129, the very next sentence, it does say, in considering whether and when to offer virtual hearings, agencies should consider. I do think the whether in there is really in tension with that first sentence, because that first sentence says they should offer it, with some caveats. But then the next sentence says, in considering whether to offer them. I guess I just would like to hear the committee's thought about why the whether given the first sentence. Why not just say something like, in developing policies on offering virtual hearings, agencies should consider, and obviously you don't offer them in some circumstances because of the factors that are considered there. But why the whether there? I think that might be the real spot where I think Paul's objection says this is sort of Janus space. It's looking in both directions in the very, from the very get-go there. So I'd just like to know what the committee's thought was on that.
Nadine, may I look to you?
I'm not sure that we focused largely on that language. I do think that there was some, you note the caveats. I mean, obviously agencies are going to consider whether to do this consistent with their needs. And there are several factors that they might take into account in doing that. We could delete the entire phrase and just start with agencies should consider. And maybe it's implicit what we mean there, since it follows from the first sentence.
Well, I wouldn't move that, because I do think the first, in the second sentence, just delete the
in considering phrase.
Well, I would support that. That I think does make it a little, a little bit more of a push towards doing these things.
I mean, the caveats are there, the factors are there, and agencies are going to take into account, really, when to use it.
Right, that's true. But it does start off by saying agencies should offer hearings. Yeah, consistent with their needs. But, the very first language right out of the gate is a recommendation that they should do it.
Hi, Feldblum.
So, as someone I said on the committee talking about this, I actually like, John, your suggestion of saying something like, in developing a policy regarding virtual hearings, agencies should consider. Okay, I like that, because we really were trying to thread this needle. We really were. And yet, as a committee, we did want to push agencies. We wanted to say what we said in that first sentence. You should offer virtual hearings consistent with their needs, in accordance with the principles of fairness and efficiency, et cetera. And we do say that they should develop a policy. Don't just do it, ad hoc. So I just want to speak in support of a modified form. Well, not modified, just in giving the words of what you were saying.
I like that.
It certainly coheres better. Nadine, what is your thought on this, John Duffy's amendment?
I guess I think I'd have to look closer, and Jeremy may be able to help me with this, we were looking at more than just policy, right? There's also rules, procedural rules that might be impacted.
Well, you could say
a program, developing a program. I don't know. I'm trying to think of a better word there, but.
Ron Cass, you're recognized.
Thank you. I don't know the full panoply of settings in which we may be thinking about whether these are appropriate or not appropriate, and if they're appropriate, how they're appropriate. For some agencies, the entire panoply of proceedings, it may not be appropriate for virtual hearings. For other agencies, it may be virtually everything they do is appropriate for virtual hearings. And I think that we have a very thoughtful list of what to do in holding them, what agencies should consider and think about. I think it's a little presumptuous to jump in and say, while we think agencies should really think about this and should consider very heavily whether and how to hold these, and then to say, but do it. I think that step is not supported by the report we have in front of us, and it's not supported by the recommendation as they came certainly to the council. So I would be cautious about making that move.
John Siegel is recognized. John?
Sorry, just took a moment to find the unmute button there. While agreeing that Professor Duffy has a fine point, I just wanted to say that no matter how strongly you get rid of the whether in that second sentence, if you look down the list of criteria that the agency are to consider, it seems evident that the conference is leaving open the possibility that they will decide not to hold these hearings at all. I mean, just look at whether the nature and type of adjudicative proceedings are conducive to the use of virtual hearings. And some of the ones that are on the next page also seem to me, at least implicitly, to leave open the possibility, whether it will affect the representations of parties, whether it would affect communication. So that's why I like the modified suggestion in developing a policy. I mean, if you want to take out and considering whether, I think that's okay. But I think it is implicit in the list of things to consider that there will still be some possibility that they will not be used.
So, John, you support the language?
I support the language that's on the screen now.
Okay. Ron, you have opposition to that language?
I'm fine with the language on the screen right now.
Does anyone else wish to be heard about the language on the screen, which I'll call the Duffy Amendment? Is there any objection to the Duffy Amendment? All right, without objection, the Duffy Amendment is adopted. Thank you. I think agencies will get the point. Are there any additional amendments on this recommendation? Jack, you don't have anything? All right, if not,
I have nothing. Thank you.
Okay.
I have nothing.
I just wanted to make sure. So we'll move to a vote on the entire recommendation. All those in favor of adoption of the recommendation, please say yay.
Yay.
Yay. And opposed, nay. The yeas have it, and the recommendation is adopted. Now, what we're going to do now is we're going to turn to Reeve Bull's long-delayed remarks on our pending projects. And so we'll turn to Reeve for an overview of our pending assembly projects, by which I mean those anticipated to result in proposed formal recommendations for the Assembly's consideration, and selected research project of the Chairman's office. Reeve?
Fantastic. Thanks, Matt. So for purposes of being brief, this, as Matt indicated, is a selected sketch of projects that we have. But nevertheless, we have a decent number, so I'll try to be very quick as I move through these. And in that light, if you want additional information about any of these, please go to our website. A couple of these don't have web pages yet, but they will very, very soon in the next few days. And as Matt also mentioned, we'll be sending out a list, a full list of projects next week. So that'll be a useful reference source as well. The first few projects, the first list of projects are those that we contemplate will yield a recommendation. Some of these are for December of this year. A couple of them are for June of next year. The first one on the list is a study of automated legal guidance. This is sort of an interesting and increasingly salient issue, and it sort of goes back to the work we've done in the AI space particularly. Agencies are increasingly using things like chatbots or other online tools to provide customized guidance effectively on specific issues that people may pose to the agency. And as you would guess, it's obviously extremely important to ensure that that guidance is accurate. And of course, the agency includes appropriate disclaimers as to the extent to which you can rely on the guidance and so forth. Professor Joshua Blank at UC Irvine Law School and Leah Sofsky at UNC recently wrote an article on this very topic, and they will be our consultants on this project. So they're certainly the experts. We think it's a very interesting issue and should yield some interesting recommendations. The second project listed is on public availability of inoperative agency guidance. So as you recall from a few plenary sessions ago, we had a recommendation, 2019-3, on public availability of guidance generally. And during the floor of the plenary session, several of you raised the question, well, what about inoperative guidance? What about guidance that the agency no longer follows, which can still be useful, perhaps in litigation or for tracking developments in the law and so forth. So this project takes up that very issue. Now, obviously, this will be very, very sensitive to the agency's resources. As a general matter, you can't put up everything. And there are also questions as to the usefulness. If you just put everything on a single website, that may not be particularly valuable. So this project will be very sensitive to those limitations. The third project is one on quality assurance systems and agency adjudication. So you'll recall from last plenary session, recommendation 2020-3 looked at agency appellate systems, which is one manner of, if you will, assuring quality. But there are also other systematic programs that agencies have put in place that try to ensure that the quality of the frontline decisions are as high as possible. And in particular, in high volume adjudicative systems, there are a number of programs that have been rolled out, some using AI, that serve this function. Our consultant team includes Dan Ho at Stanford, who, as you'll recall, was one of our consultants on the AI project, so he's obviously very steeped in these issues. It also includes David Marcus and Gerald Ray, both of whom have worked extensively with ACUS in the past and are real experts on this topic. The fourth recommendation project we have listed is regulation of representatives in agency proceedings. So in the last several decades, many agencies have adopted rules governing the conduct of representatives who appear on behalf of parties before the agencies. This can include both attorneys and non-attorneys. And there's a high degree of variation in these rules, much of it, of course, eminently appropriate. But it also appears that there's some opportunity here for sharing of best practices, ensuring agencies are aware of what their sister agencies are doing, and considering some of the factors that go into how they put together these rules. Our consultant on the project is George Cohen at UVA Law School, who also has written one of the definitive articles on this topic. So he's very well positioned to research this. The fifth project we have highlighted, recommendation project, is public access to agency adjudicative proceedings. As you'll recall from past recommendations like 2016-4 and 2020-3 that I just mentioned, we presumed as a general matter that adjudicative hearings are open, presumptively, but there may be certain cases in which agencies do decide to close adjudicative proceedings if there's confidential information being considered or so forth. This, of course, was further underscored by the recommendation we just discussed on virtual hearings, and in particular, putting things virtual really sort of raises the salience of this issue. So this project will basically take as a background matter that there are certain legal requirements, including under the First Amendment. It will look at what those legal requirements are, but it will basically look at within the range of discretion that agencies have within that legal framework, what are the factors that go into deciding whether or not to open certain proceedings, and what approaches can agencies take for the proceedings that they do open to optimize the level of openness. And the final recommendation project we have highlighted is a study of technical reforms of the Congressional Review Act. The CRA, of course, has become very salient in recent years, and notwithstanding disagreements over its proper scope, there's actually a lot of consensus that you see over some technical fixes, ways to make the CRA work better or more efficiently. And this project will focus on a handful of those technical fixes. So things like, for instance, paper reporting requirements. Agencies are currently required to submit multiple copies in paper to Congress, to GAO. And many people have testified, including the parliamentarians on the House and Senate side, that there's real inefficiency here, and that just moving to an electronic reporting would not only be more efficient, save money, but would also be a lot more transparent. We'll also look at things like counting the number of days, for instance. It's currently a very complicated process for counting legislative days. And we'll look at possible ways to simplify those procedures. So those are some recommendation projects that we're looking at. I'll even more briefly go through just a selected handful of Office of the Chairman projects. One is a study by Professor Michael Asimov on agency head enforcement and adjudicative functions. As you know, agency heads often wear two hats. They both make determinations as to prosecutorial decisions of the agency, and then they hear appeals in agency adjudicative decisions. There are benefits and costs, of course, to their doing both. And certain agencies have put in place mechanisms for separating out those functions to some extent. So this project will look at both what those benefits and costs are, and then explore some of the ways in which agencies have separated these functions in particular instances. The second Office of the Chairman study we've highlighted is a study of alternative dispute resolution and agency adjudication. ADR, of course, has been at the core of ACUS's work for decades. And the project explores the use of ADR in adjudications related to agencies' core regulatory missions. And we'll look at things like choosing the optimal type of ADR or the selection and training of personnel and other key issues. And as Matt mentioned in his opening remarks, we put together a working group or a roundtable on ADR that will also be very helpful in connection with the project. Our consultants include Judith Starr, who is a longtime government member of ACUS and now is working in the ADR space in the private sector, as well as Kathleen Clausen and Christine Blankley. The third highlighted recommendation is a study of the classification of agency guidance documents. Guidance, as we've seen, in past recommendations, takes a wide variety of forms, from the very formal or relatively formal to things like mere conversations that agencies have. This project will look at a classification scheme for agency guidance documents and look at some of the factors that go into what types of guidance agencies use. And our consultants are Professor Kristen Hickman and Mark Thompson, our Deputy Research Director here at ACUS. The first highlighted study is a look at the use of contractors in rulemaking. Contractors perform a variety of functions in the rulemaking process, including designing screening systems for comments, reading comments, processing comments for agencies, In connection with our mass comment project, we actually saw in the interviews with agencies a variety of different approaches that agencies use with respect to employing contractors. There are, of course, certain legal limitations on the extent to which agencies can use contractors, including the prohibition on contracting out inherently governmental functions. But within those legal limitations, there are a variety of best practices, and this project will look at those. The consultant team includes Bridget Dooling, a senior fellow here at ACUS, as well as Rachel Potter of UVA Law School. The fifth recommendation is a study on improving notice of regulatory changes. So, of course, there are legal requirements as to how agencies must disclose regulatory developments, in particular with Federal Register notices. But this may not necessarily always be adequate to ensure that the agency gets actual notice, or regulated parties and other interested parties get actual notice of any changes that have taken place. And this can include not just regulatory changes, but also statutory changes, new guidance document, and so forth. So this project will look at possible best practices to ensuring that interested parties get that notice. The consultant team includes Don Elliott, a senior fellow here at ACUS, as well as Josh Galperin at Pace Law School. And then the final Office of the Chairman study I'll mention is a study that Matt also mentioned in his opening remarks on nationwide injunctions and federal regulatory programs. As you'll recall, we had a well-attended program on this back in 2019. And one of the takeaways from that program is that though there are a lot of different perspectives on the propriety of nationwide injunctions, there's really not yet been a lot of empirical work done as to how extensive nationwide injunctions are, what are the courts that are issuing them, including district courts as well as courts of appeals, and then in some cases the DC Circuit. And then depending on which court is issuing it, how do agencies respond to a nationwide injunction? So this project takes up that charge. It will conduct that empirical work, looking at both what courts are doing and then what are agencies' responses to nationwide injunctions. So I believe that covers it. But again, I just reemphasize, we'll be sending out a full list of projects, and please go to our website if you want any additional detail on these or other projects that have been mentioned.
Thank you very much, Reeve. We finished the business on our agenda with the caveat that our recommendation clarifying statutory access to judicial review has been remanded to the Judicial Review Committee to address one discrete, albeit maybe thorny issue. I anticipate that the Judicial Review Committee will complete its work on the recommendation this summer, and then with the council's approval, we would have an asynchronous plenary session, as it's called, basically a session in which you would vote by email on the committee proposed recommendation. I want to thank our members for giving ACUS their scarce time at this plenary session and, of course, throughout the year. I also want to thank especially our staff for their excellent work yet again, and especially under the difficult circumstances of the pandemic. I'd like to single out a few members of our staff who don't get a whole lot of, if any, recognition during our plenary session, and they include Sean McGibbon, our general counsel, and Harry Seidman, our chief financial and operating officer, and Jennifer Alvarez, our program manager, who runs around and keeps all the trains on working, and Nathan Tomaso as well of our staff. And I'd also like to thank Jeremy Grayboys, who's done a lot of the coordination of our virtual activities during the run-up to the plenary. So thank you, Jeremy. Jeremy's just to my left here. And so with my sincere thanks again to all of you and my very best wishes for an enjoyable summer, I adjourn this plenary session. Thank you very much.